And welcome to the City of St. Pete Beach Code Enforcement Special Magistrate hearing for April 8th, 2024. My name is Erica Augello, and I am the appointed Special Magistrate to hear today's cases. I am a practicing attorney licensed by the Florida Bar and am board certified in city, county, and local government law. I have been appointed to this position in accordance with the authorities set forth in Chapter 162 Florida statutes and the City of St. Pete Beach Code of Ordinances. I am not an employee of the City of St. Pete Beach and do not represent the city here today, and I do not confer with the city's code enforcement officers outside of the hearing process about your cases. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order on which they appear on the agenda, unless otherwise agreed. Every effort will be made to hear all persons having relevant evidence, arguments, or comment related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in, which I will do momentarily. All testimony given will be done so under oath. In all cases, since the city has the burden of proof, the city will present its case first. The respondent will then be given an opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will make every effort to ensure that fundamental fairness and due process is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and all parties will be provided with a copy, so please ensure that we have your current address or email address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and, under some circumstances, to provide a reasonable time to correct the violation by whatever means are available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline, if one is provided. If you wish to present any evidence today, please sign in before you speak at the podium, and it will be necessary that you swear or affirm to tell the truth. Therefore, at this time, I will swear in any witnesses. Anyone wishing to speak today, please stand and raise your right hand to be sworn. Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
Yes.
So sworn. Are there any changes to the agenda this morning, Mr. Dewar?
Madam Special Magistrate, good morning. Pete Dewar on behalf of the City of St. Pete Beach. There are none at this time.
Okay. Okay, then we shall move to agenda item 3A, case number 20230616, City of St. Pete Beach versus Anthony J. Perrone. Would the city like to make its presentation?
Yes, good morning, Special Magistrate Louis Cruz representing the City of St. Pete Beach Code Enforcement. If you could put the overhead over for me, please.
This one on the agenda.
As you know, Special Magistrate, the respondent was supposed to get the permit obtained by 3/15/2024. It looks here that it was denied on 3/11, so he has not acquired that permit by 3/15/2024. So the city will be asking for the previous recommended fine of $250 per day from 11/18/2023. plus $325 in administrative costs until compliant.
Okay, is there anyone here on behalf of the respondent property owner? Mr. Perrone, or anyone on behalf of Mr. Perrone? Okay, seeing nobody here on behalf of the respondent, I will go ahead and find that the property is still not in compliance. And I will go ahead and issue my order stating that there will be daily running fines of $250 a day starting on November 18th, 2023 until the property comes into compliance. It is the respondent's responsibility to notify the city when the property is compliant, and I will also allow for the $325 in administrative costs. Moving on, case number 3B, case number 20230561, City of St. Pete Beach versus SJ Beach Properties, LLC. Would the city like to make its presentation?
Yes, thank you, Special Magistrate. Louis Cruz representing the City of St. Pete Beach Code Enforcement. This is a true and accurate representation of what I have witnessed. If you could put the overhead on for me, please. The respondent did not reach out to the city to try and get a permit for the gazebo. For the last one that was remaining, it has been removed. And the property is now compliant, so the city will be asking for just the $325 in administrative costs.
Okay.
Thank you.
Is anyone here on behalf of the property owner, SJ Beach Properties LLC? And Mr. Cruz, did you by chance speak to the property owner anytime between the last hearing and today?
Not the property owner, one of her
Or-
friends or like
okay.
attorney friend that reached out that I had talked to previously trying to get it dealt with. He reached out and let me know about it. So that's why I went and checked, and unfortunately, I wish they would have tried. It looked nice, but unfortunately, they just removed it.
Removed it, okay. And you said it was $325 in administrative fines?
Yes.
Fees?
Yes, ma'am.
Okay. I will find that the property was in violation, is now compliant. I am not going to assess any daily running fines, but I will go ahead and assess the $325 in administrative costs. Moving on to agenda item 3C, case number 20230602, City of St. Pete Beach versus Ping Pong Partners LLC. Mr. Cruz?
Yes. Thank you. Louis Cruz, representing the City of St. Pete Beach Code Enforcement. For the respondent, it looks like they did acquire their permit on 3/22/2024. The city will be asking for just administrative costs totaling $325.
Okay. And I believe the respondent is here.
Thank you. Yes, we were able to obtain our permit. I think our actual final inspection is scheduled for today. So as you recall, in the previous hearing, it was established that we didn't receive reasonable notice and of the actual violation so that we could have solved it. But I hope that our behavior has shown that we would have resolved it if we had received notice. And so therefore, I would object to any administrative fines, but I would ask you to dismiss it now. Thank you.
Okay. Mr. Cruz, any response, or the city have any response to that?
I think the response is we continued it. We gave sufficient time. The property owner showed up to the meeting, so I understand while notice may not have been sent reasonably, he did receive notice of the hearing. Magistrate gave him, I believe, 60 days to come into compliance. He did. We're not asking for fines. We're simply asking for admin cost.
Again, I think we're conflating the issue of reasonable notice. So we did not receive reasonable notice of the actual violation so that we could attempt to comply it prior to it being entered into this administrative process. And it would obviously be unfair to assess costs. Thank you.
Okay, I do find Mr. Hardin's argument to be reasonable, so I will find that there is no violation on behalf of the property owners. The property is now in compliance due to the insufficient notice of the actual violation, and I am not going to assess the $325 in administrative costs. All right, agenda item number 4, we have no repeat violations. Moving on to agenda item 5A, case number 20240090, City of St. Pete Beach versus Franklin L. Dockett. Would the city like to make its presentation, Mr. Rivera?
Yes, good morning, Madam Magistrate. Steve Rivera on behalf of the City of St. Pete Beach Code Enforcement. Sorry about that.
No worries.
Case number CE 20240090. Respondent is Franklin L. Dockett. Violation address is 555 Gulf Way, number 7N. Violation description, the property is in violation of 98-123.1 permits required of the Code of Ordinance of the City of St. Pete Beach. Case summary, initial inspection was 2/8/2024. Notice of violation dated 2/9/2024. Notice of violation compliance date was 2/23/2024. Notice of hearing dated and posted to the property 3/14/2024. The following is a true and accurate representation of what I witnessed. This is the affidavit of posting. It's a picture of the gentleman working on the drywall in the back there. Corrective action, property must obtain a permit for the drywall that was replaced without a permit. Property is not compliant. Recommended fine is $250 a day from 2/24/2024 until property is compliant, plus $325 in administrative costs. That concludes my presentation.
And Madam Magistrate, before we move on,
Sure.
unless you have a question.
I do have a question for Mr. Rivera.
Okay, I was just going to call up our building official.
Okay, give me 1 second, let me ask. And Mr. Rivera, how did you find out about the drywall being installed and gain access to the property?
So this was from a complaint from one of the board members at the condominium where they live.
And the condo, who let you into the unit?
It's knocked on the door, the property owner let me in.
The property owner let you in? Okay. All right, then the
Yeah.
city may call second witness.
Mr. Curtis, if you could just come to the microphone and announce yourself and your position with the city.
My name is Luke Curtis. I'm the building official for the city of St. Pete Beach.
Thank you. I just have one question. The installation of drywall, does that require a permit pursuant to the building code?
Yes, it does. In basic terms, just about any work that's being performed per section 105.1 of the building code, all work requires a permit.
Okay, thank you.
Okay. Does anyone hear anything further from the city?
No, Madam Magistrate.
Okay, anyone here on behalf of the property owner, Mr. Dockett? Okay. And if you'll just state your name for the record.
I was told by the contractor when he started that he didn't need a permit for drywall repair.
Okay, and Mr. Dockett, I presume?
I'm sorry?
Is your name Mr. Dockett,
Yes.
Franklin Dockett? Can you tell me what was the extent of the drywall? You said it was repair.
One full wall in the bedroom and another short wall by the window.
Okay, and what was the reason for the repair?
We had a window leak years ago, and there was a lawsuit because of it. All the walls were taken down because water had gotten into mold all through the drywall, so that was all taken out. All the insulation was taken out, and then this fella came in, put in new insulation and put in new drywall, and he said there was no permit required just because it was a repair. That's all I know about it.
Okay, and did you receive the notice of violation that stated that you had to comply by a certain period of time?
I didn't get one. They were emailed, certified mail. One was mailed on the February 12th. I never got it. So then there was another one on March 16th. That one I got, and I came in to find out what was going on.
Okay, so you didn't receive the initial notice of violation, but you received the notice for hearing. Is that correct?
I had a notice on the door.
There was a notice on your door. Do you remember what date that was?
Okay?
The notice on the door, do you remember what date that was?
3/14.
3/14. So notice of hearing. And is there anything else that you would like to tell me about the situation so that I can effectively rule?
I have contacted a number of contractors on Google, and they said that they wouldn't work here because of the rules. And then I finally found one, and he supposedly is in the process of putting in for permit. It should be in this week. His outfit is called Flagstone Builders.
Okay, and do you happen to know how long it might take him to apply? You said this week he would have the application for the permit in?
I'm sorry,
You said this week he would have the application for the permit in?
yes.
Okay, and is the work already completed?
No, there's a very little bit left.
Okay. Do you have any idea, or had he let you know any idea, excuse me, of how long that permit process would take?
I have no idea how long.
Okay. Okay. Any questions from the city for Mr. Dockett?
No, thank you.
And Mr. Dockett, do you have any questions for the city that you'd like to ask them?
Well,
Either their building official or the code enforcement officer?
I just didn't know that there was a permit required because I was told there wasn't one. So maybe there should be some way of notifying people in advance, I don't know.
Okay.
Yep.
All right, thank you very much.
Thank you.
And Mr. Curtis, how long are after-the-fact permits taking this type of a permit? Do you have any idea how long that review process would take?
It all varies between, for the scope of work, but for something simple like this, it would, maybe 2 weeks.
Okay, great, thank you very much. All right, anything further from the city?
I just have one point of clarity from Mr. Rivera. Is the compliance request to obtain a permit?
So that was part of the corrective action, would be to obtain a permit, finalize out the permit.
So obtaining,
It's-
Obtain the permit.
Obtain or final?
Well, he can obtain it. At this point, there was a stop work order issued, so
Okay.
we'll probably see it through until it's compliant.
and then would this be considered an after-the-fact permit because work has already started but not been completed? Yes.
That'd probably be a better question for Luke, yeah.
Okay, and Mr. Curtis, you're nodding your head yes for purposes of the record? Okay. Okay, great. Okay. I am going to find that there was a violation. However, I am going to give the respondent 30 days from the date of my order to secure a permit. I know the request is to secure and finalize. I think that probably can be done, but I am going to just do it to secure a permit for this project. And then we will see, after the 30 days, we'll come back and see where we are with that. Okay.
Should we set it, if I may, Madam Magistrate, should we set it for May 13th? Not to
Yeah,
pressure you, but if you get it this week.
yeah,
then-
that's sufficient time for me to draft my order and get
Okay.
it out.
All right.
So, yeah, we can do a date certain. We'll come back for a case status conference on May 13th. And Mr. Dockett, did you understand my order? I'll get you a copy of it, but did you hear what my order was?
I have to be back May 13th, you have to have a permit by then.
Correct. Okay, perfect. All right, then, thank you very much, and we will move on to the next case. Case number 20230685, City of St. Pete Beach versus Billy G. Lambert. Mr. Cruz?
Yes, thank you, Special Magistrate. Louis Cruz representing the City of St. Pete Beach Code Enforcement. Case number 2023-0685. Respondent is Billy G. Lambert. Violation address is 7951 Gulf Boulevard. Violation description: the property is in violation of Section 98-65 Unsightly Conditions 4 and 98-66 Residential and Commercial Property Maintenance, A, B, 2, A and B, 6, and 7 of the Code of Ordinances of the City of St. Pete Beach. Case summary: the initial inspection was 12/8/2023. Notice of violation dated 2/27/2024. Notice of violation compliance date 3/5/2024. Notices of hearing dated and posted on the property 3/14/2024. These are a true and accurate representation of what I have witnessed. This is the affidavit of posting at 7951 Gulf Boulevard, March 14th, 2024. And on the left side of the property there's broken siding and deteriorated paint that has faded very badly. Some deteriorated paint there over in the overhang, as well as outside storage. There's some more fading of the paint on the siding. And the door frame that looks to be in disrepair. Looks like it's rotted wood there underneath the paint. Just some updated photos on what it looked like after the compliance state, the deteriorated paint on the property. Looks like the outside storage was removed, but after compliance, the compliance date on the notice of violation. Corrective action, the property must paint the exterior of the building, fix the rotted door frame, and fix the siding that is broken. The property is not compliant. The recommended fine is $250 per day from 3/6/2024 until property is compliant, plus $325 for administrative cost. And that concludes my presentation. Thank you.
Anyone here on behalf of the property owner, Billy G. Lambert? If you could please state your name for the record, and you can make your presentation.
Billy Lambert. So the house was quitclaimed to me from the gentleman who owned it, passed away, and his family left the house to me. When I first got it, there was a squatter in there. So there was a lot of stuff inside the house that I moved out. And Mr. Cruz, actually, I spoke with him, and I got all the stuff off the patio right away. And I've hired a construction company to do the outside, but everything's taken time. And I also had to get an equity loan on my house to help with this one. So it's been taking a while, but I'm working on it, and I can't afford all those fines on top of the loan, so.
Okay, and so you're saying you're already working with someone to repair the outside. How long do you think it would take?
Permit's been filed.
Okay.
For, and I have a quote on redoing the lawn. I guess they have to remove the rock to get all the weeds out of there. But I've gotten a quote, and everything's been filed, so
Okay.
I'm working on it. It's just taking time.
Sure.
Nobody moves fast.
Sure. So it looks like the things that the city is most concerned about, and Mr. Cruz can correct if it's wrong, is the paint, the siding,
And that's what.
and the door rot.
And the windows. The permit has been filed, so.
Okay, so do you have any idea, or has your contractor told you of what the time frame on securing those permits and getting that completed is?
I got an email this morning that just says it's been filed. I don't know. Isn't that you guys? How long it takes for you to?
Not me, I'm not with the city, so I'm independent, but even so, okay, so your contractor has not let you know, given you an estimate of this will be done in 6 weeks, or
As soon as they get the permit, they'll get working on it.
they can get working on it, but
Yeah.
you don't know what that time frame is?
I don't know. I don't know anything about that. So once the application for permit is filed, so then how long does that take? I don't-
Obviously, it varies, like Mr. Curtis had spoke to before.
Correct.
Some of them are more substantial compared to some drywall, so they can take a little bit more time. But you kind of stated it perfectly. City's only really looking for the paint, the siding, and the door,
The
the
siding
door
has to
frame.
be replaced,
Yeah,
so it's
yeah.
a big job.
Mhm.
It's not just paint.
Which is understandable, and I had reached out, trying to get some type of confirmation or some type of quote from some type of contractor. I did not get that. And then,
Didn't I email that to you?
I did not receive it. But unfortunately, we're here today, and hopefully we can get it taken care of, but it depends on what type of substantial work that I can't speak to, on how long that permit will be. It could be a couple weeks, could be a month, depends on what she's trying to do.
Understood, understood. Okay. And Ms. Lambert, do you think that 30 days would be sufficient, or maybe 45, 30 days would be sufficient?
30 days is sufficient.
Okay, would be enough for you to get the permit and have the work all completed?
Well, can they complete all that in 30 days?
I mean, I don't know, that's going to be up to your contractor.
Then let's say yes. And then I'll push for that to be done.
Okay.
Okay.
Any questions from the city? Anything else? Okay, so I am going to find that the property is in violation, but I'm going to give you 30 days from the date of my order to get the permits and get everything repaired. We'll come back on May 13th at the 10 a.m. hearing, and we'll see what progress has been made. If there's substantial progress that has been made, or if it's complied with, then we should be good, and we can evaluate fines or fees at that time. And you may not be subjected to any fines if everything is completed, okay?
Thank you.
Okay, so we'll do that, and I will get you a copy of the order. Just make sure we have your name, your address, or your email address.
It's on there. Okay.
All right, thank you, Ms. Lambert. Okay, moving on to case number 2024-0133, City of St. Pete Beach versus Patricia E. Little, trustee. Would the city like to make its presentation, Mr. Cruz?
Yes. Thank you, Special Magistrate Louis Cruz, representing the City of St. Pete Beach Code Enforcement. Case number 2024-0133, respondent Patricia E. Little, TRE, violation address 85 Corey Circle. Violation description, the property is in violation of section 46-33 enumeration 12 and 13, 78-96 business tax receipt required, and 98-67 junk vehicle, junk vessels, and abandoned property, E and F of the Code of Ordinances of the City of St. Pete Beach. Case summary, the initial inspection was 3/5/2024. Notice of violation dated 3/5/2024. Notice of violation compliance date 3/15/2024. Notices of hearing dated and posted on the property 3/19/2024. This is a true and accurate representation of what I have witnessed. This is the affidavit of posting at 85 Corey Circle, March 19th, 2024. This is the junk and abandoned vehicle that is on the property at 85 Corey Circle. No license plate. It is unregistered. It is in a state of disrepair. Inoperable, I should say. Updated picture of that. Corrective action, property must have junk and abandoned vehicle removed or registered and brought into an operable condition, and business on the property, which is Blue Parrot, must obtain renewed business tax receipt. Property is not compliant. The recommended fine is $250 per day from 3/16/2024 until property is compliant, plus $325 for administrative costs. And if you could put on the overhead for me, please. Would like to show, this is just the front side, that the business owner on the property of 85 Corey Circle, I went in person. He also has been sent multiple, whatever he puts on the for the business tax receipt itself when you put in the application. He has, references for our permitting manager to reach out to him via email, sending out mail to, their home. He was reminders were sent, on 7/18/2023 and 3/5/2024, as well as me going out there personally. And every single business tax receipt each year is due 9/30/2020. Well, this one was due 9/30/2023, but each year the business tax receipt needs to be renewed on 9/30 of every year. And that concludes my presentation.
And Mr. Cruz, is the business still in operation?
Yes, ma'am.
Okay, and the picture that you showed of the van that is parked, you said that was located on the property?
Yes.
It's located on the business property?
Yes.
It is not on a city street or highway?
Yeah, on F, I put that on accident, but E does pertain, but F not so much. But yes,
Tell
it
me
is
what
on the
in
property.
E says that you can't have a junked vehicle.
It's the registration for E.
I mean, I understand, but E says absent of a current license plate or current registration as prima facie evidence of abandonment. It says for the purposes of enforcement of this article, the absence of a current license plate or current registration on a vehicle or boat shall be prima facie evidence that the vehicle or boat is abandoned, junked, or discarded. So great, it doesn't have a license plate on it, that's prima facie evidence, but you've cited to E, which says that in order to be considered junked or inoperable or otherwise in violation of the code section, it must be located on a city street or highway. And your testimony and the evidence presented says that, yes, it doesn't have a current registration, but it's located on private property.
Yes.
Is that correct?
Yes, it is on the private
So-
property, it's on the business part.
Yeah, if I may, Madam Magistrate, I think F pertains to the right-of-way. E, without registration and license plate, it deems it abandoned or junked, and that's a violation of E in itself, regardless of where it's parked. There's no specification that it needs to be on a right-of-way or a street. It's just deemed abandoned by not being registered, regardless of the location of the vehicle.
Yeah, nothing in E says that all E describes, unless you would like to make argument to the contrary, all E describes to me is what prima facie evidence of an abandoned or junked vehicle is. Basically, it would be a definition of an abandoned or junked vehicle, not that having an abandoned or junked vehicle is otherwise a violation. It says the presence of a current license plate or registration solely shall not in and of itself exempt any vehicle or boat from the provisions of this article. And there's nothing in E that says that in and of itself that you could be violative of it. F is where the violation would be, and it says on any street or highway. It doesn't say a right-of-way. So if you have argument to the contrary, I would entertain such, but I just don't see it that way.
Okay. I just have one question for Mr. Cruz, if I may.
Yes.
Are you for certain that this is on their property? Do you have a survey? Did they provide anything, or is it a guess?
Nothing of that nature. It's a guesstimation going off of property appraiser.
And a follow-up question, are you for sure certain that this is on city property or a street or highway?
No, I am not.
Okay, so you, as you sit here today, your best guess is that it's on business property, but you just don't know?
Yes.
Okay. All right, anyone here on behalf of the property owner, Patricia E. Little, trustee? Anyone here on behalf of Patricia E. Little, trustee, business owner? Okay. At this time, I am going to find that there is a violation of section 78-96 for the business tax receipt. I am going to, before I make my ruling, Mr. Cruz, how long does it take typically to apply for and receive a business tax receipt?
You could walk in same day, which I expressed to the business owner. I brought him over a payment slip and everything to fill out a check, and it's right across the street from city.
All you have to do is pay. There's not an application process or anything. It's just a renewal.
Just a renewal, yes.
Okay, thank you. I am going to find that there's a violation of section 78-96 business tax receipt for the property. I'm not going to find that there are any other violations of the cited code sections. I am going to give the property owner 3 days from today's date. Let's make it 3 days consistent.
Madam Magistrate, what about 4633? Because while I can understand your point on 9867, 4633 specifically says on any public or private property, defines worn out, and it's the storage of such.
Okay. And that does say on public or private property.
Correct.
So, okay, thank you for bringing that to my attention. So yes, I will say that I will find that there is a violation of section 46-33 and section 78-96, but not of section 98-67. I am going to allow 3 days from the date of my order to secure the business tax receipt. And I am going to give 14 days from the date of my order to contend with the abandoned or junked vehicle, either to register it or to remove it from the premises. And I will get that in writing and get that to the property owner and the city.
So will fines be retroactive if those dates are not met?
I will make a finding on fines and fees at the next hearing.
Okay.
Per chapter 162. Okay.
Can I assume status hearing on May 13th?
Yep.
Okay. Thank you.
Unless they come into compliance and y'all don't seek fees. Okay, moving on to agenda item C, case number 202401333, City of St. Pete. Oh, no, we just did that one. Sorry. Moving on to item D, case number 202400043, City of St. Pete Beach versus Thomas J. Dillon III.
Yes, thank you, Special Magistrate Louis Cruz, representing the City of St. Pete Beach Code Enforcement. Code Enforcement case number 2024-0043. The respondent is Thomas J. Dillon III. Violation address 422 86th Avenue. Violation description. The property is in violation of section 22.4, type, quality, and size of plant material, F, of the Land Development Code of the City of St. Pete Beach. Case summary, the initial inspection was 1/19/2024. Notice of violation was dated 2/7/2024. Notice of violation compliance date was 2/28/2024. Notices of hearing dated and posted on the property 3/27/2024. These are a true and accurate representation of what I have witnessed. This is the affidavit of posting at 422 86th Avenue, March 27th, 2024. This is what the property at 422 86th Avenue looked like previously in 2019. Around that time, they did have grass in the front yard, side yard. This is now vegetative ground cover being replaced with pea pebbles. The whole frontage, sides of the yard, this is the right side of the property, and it looks like some into the backyard. And this is the left side of the property. This was just updated pictures. Corrective action, property must comply with section 22.4F. Property is not compliant. Recommended fine is $250 per day from 2/29/2024 until property is compliant, plus $325 for administrative costs. That concludes my presentation. Thank you.
Okay. Anyone here on behalf of Mr. Dillon? If you'll please state your name and affiliation for the record, please.
Good morning, Special Magistrate. My name is Tom Dillon. I'm the deed property owner of 422 86th Avenue in St. Pete Beach. I'm a resident of Virginia. I've owned this property since 2019, and I sort of have another side of the story to tell from the city, if you'll entertain that.
Certainly.
I first received notice that this was a problem back on February 20th. I'd been out of town. I went to my post office box. I had received a certified letter, and I was completely thrown off by it. I'd never heard of the regulation before. I wasn't aware of what was done to the property was a violation. At the time that I elected to put down the landscaping, it was consistent with a fair number of properties that are in the neighborhood, so it wasn't out of line, and it seemed consistent with it. I hired a professional landscaper to do it. The landscaper did not advise me that there was a problem, and I had just finished, or my next door neighbor had just essentially done the same thing. And so I offer that evidence in terms of my thought of mind at the time that the act wasn't intentional, and being out of town, it takes me a little while to get things done down here, but I've owned property in the city since 2008, and I've never appeared before anyone in this context. I'm also a lawyer in Virginia and not barred in Florida, but, you know, it also, I guess I take some of that more seriously than others might. But I want to show Your Honor a photograph of the property as it has been for the last couple of years. Now, I don't know if you want me, I'd like to create a record of this, if I may, and so I don't know if you want me to introduce as exhibits or whether you want to have the photograph or to put it up on the...
Well, if you want to introduce them as exhibits, then I would suggest you can certainly do so as record evidence. Just make sure that the city attorney gets a copy or can see them before. Absolutely. And has an opportunity to object, and then just also make sure that we have copies for the clerk so she can take them for the record.
So I have 3 copies of each, and so I'd be happy.
Yeah, do you mind?
To show.
Are these all of the pictures? I didn't know if you wanted to show me
I don't
them
know
all.
how many I'm going to
Okay.
introduce at one time, but that's the...
And then you can place one for the overhead, and that way, that can be the clerk's copy if you wish.
Okay. And then I'd like to introduce this as exhibit number 1, a photograph of the property depicting the property from my perspective and as property owner for at least the last several years.
Okay.
So when I first bought the property, it did have a lawn, and for whatever reason, this is a rental property, and I leased it, and for whatever reason, the front lawn went away. So I have been trying from that point forward to have grass grow there. Even some of the tenants that have lived there that didn't want just exposed bare ground also tried growing grass, and for whatever reason, it was not growing. And so that led me to install some landscaping because there were at least 2 floods that occurred during the time of my ownership of this property. One was in connection with a hurricane, one was just a flood. Both of the floods came up about halfway to the center of the lawn, and it's just been a big challenge. And so I've certainly recognized that you know, without admitting that I wasn't aware of the restriction of 20%, and I, you know, put it down thinking that I was preventing erosion, that it was consistent with many of the other properties that are in the neighborhood, and that it would actually improve the street appeal of the property. So when I got that notice on the 20th at the post office, I immediately called Mr. Cruz because I was thrown off by it and wanted to understand what was going on. And I explained to him that I'd been out of town and I had just gotten it because it apparently had been sent much earlier. And I asked for an extension. And he agreed to that extension and asked me to send him an email, which I did, and he responded to. So let me just at least for the record here, I'd like to introduce as exhibit number 2 my phone record from calling Mr. Cruz on the 20th. So that's Mr. Cruz's number. That's the number that was posted on the letter that I received. And then as a follow-up to that, I then had an email exchange with Mr. Cruz about that. So what I'd like to do is introduce as exhibit number 3 my email exchange with Mr. Cruz relating to the phone call of that same day. It's over 2 separate pages, so I'll have to, I guess, do it in 2 parts here. But you'll see I am sending Mr. Cruz the email that he requested that I send to him and asking him to, for an extension. I wasn't sure at the time, frankly, what I was going to do about it, how I was going to handle it, what the action was going to be. We didn't discuss an extension date, but I left, I guess, my phone call and email exchange with Mr. Cruz believing that I had an extension. He responded back. You can see that. Please keep me in communication, updated on findings and resolution. And so after that, I contacted Kristen Conlon of the city. And I'd like to introduce is exhibit number 4. The contact information that I've used, as well as my phone records for that.
So far, the city has no objection to any of this.
So I'll show first, that was the information that I used to contact her, and then my phone records showing I left a voicemail for her because I was going to try to explore with the staff how can I resolve this in a way I don't want to be sideways with the city, and I never heard back from her. So I figured, well, my plan then will be to try to get it fixed and hope that it will comply with what the city's expectations are. So on March 4th, I reached out to the landscaper that installed it, explained to him, hey, you didn't tell me you can't put down this amount of that type of landscaping in the city, and sent him a survey. So as exhibit number...
We're on 5.
5. So I'd like to introduce this as exhibit number 5. These are my emails, or texts, I guess, to my landscaper who I asked for what the cost would be to undo it. And in connection with that, I had sent him a survey, which I would like to introduce as exhibit, or part of the survey, which I'd like to introduce as exhibit number 6, which shows a portion of the front yard, which I was asking him to quote me on. so that I would hopefully be able to come in compliance. And so, if you look at the, I'm by no means an expert on the city code, but my understanding is that there are areas of the property that have to be permeable for water, and there are areas of property that aren't. And so, for example, the property immediately across the street from this one is putting in a pool. When that pool goes in, there's going to be a certain portion of that area that's not going to be permeable. And another property's expanded a driveway. You could do an addition. So there's all this space that you can have impermeable structures or surfaces on. And then the remainder part, as I understand the code, is 20% of the minimum permeable space, meaning the water will flow through into the ground. So what I wanted to propose to the city, if I had gotten in touch with them, and I'll show you some additional efforts to do that, was to say, listen, I'll agree, I won't put an addition on, I won't expand the driveway, I won't put in a pool, I won't do all these other things that I could do if you'll allow a greater amount of the pebble landscaping, because it's very easy to find a landscaper who will put it down. It's very hard to find a landscaper who will rake it up and remove it. And so I found that out a little bit the hard way. So what this depicts, Your Honor, is that I was going to say, if you will allow me to have pebbles, or if the city would allow the landscaping on the side of the driveway and the side yards and some portion of the backyard, that I would reinstall a lawn grass there. Now, the one thing that I'm worried about with that is that due to the lack of success that I've had in the past, I'm worried I put the sod down and it dies. And then I'm in sort of the same position, that I was in before. So I wrote to the mayor because I wasn't really sure. I looked at online what was available on variances and different applications, and I really wasn't sure which one was going to apply. And in my experience as a lawyer, at least in other states, the mayor's office will usually direct you in the right spot if you don't know. And so as exhibit number 7, I'd like to introduce my email to the mayor of the city of St. Pete Beach, asking for some help as to what direction to go. And I would ask Your Honor to take a moment to read that, because I think that is a good explanation of essentially what happened, where I am, and what I'm looking to accomplish to do.
Okay.
Okay. So after, I believe it was in early March, that I had requested my contractor to provide me a quote. He originally pushed back because I originally asked him to remove the pebbles, and he refused to do it, and so did others. And so what we originally agreed to do is I said, well, I know I can have some portion of the surface area with that. We'll just double those up, and I'm just asking you to move them on the same property, not remove them. And he agreed to do that. And so I finally, after a fair amount of negotiation with him, on March 27th, I received a quote from him. And I'd like to introduce this. And is it number 7?
Yep.
8, I think.
8.
8.
Yeah, the letter would be 7, so this would be 8.
So I'll put this down here so you can see. It cost me a little under $10,000 to put the original landscaping down, and the cost of the repair, according to the proposal that I wanted to make, would be $6,850. And what the plan is to move the landscaping, the non-vegetative landscaping, over to areas that would be allowed, and to put in a front lawn. And he's prepared to do that right away. My concern is I want to make sure that I have a resolution with the city, and when I do it, I don't have further issues. So I'm hopeful that I can find that resolution with the city. I want to, maybe it's just because I'm a lawyer that I sort of am wired a certain way, but there's certain aspects to the notice that I received that just aren't accurate, and I think it's important to clarify that. It's in no way suggesting that I want to be uncooperative or not finding a resolution, but I think if you're going to charge somebody or make allegations against somebody, it ought to be accurate, right? And so I'd like to introduce as exhibit number 9, a copy of the notice that was posted at the door. And I didn't mention it earlier, but the email that I wrote to the mayor was never responded to. So the notice here is exhibit number 9, has attached to it the letter that I originally received. It's that the letter becomes part of the notice. And so I don't know if I need to...
That's already part of the city's record.
Yeah. So going back to the city's letter there are a number of issues here. So it says that you have removed all vegetative ground cover and replaced it with pea pebbles, which is not adequate vegetative ground cover. The pea pebbles must be removed and the ground cover must be replaced. Read that with, I would just say with adequate plant material. You're in violation of the following code. So the first error here is that I didn't remove any vegetative ground cover. If you'll recall what the city had produced, which was a photograph of the building back maybe in 2019, there's sort of a vegetative wall in between my property and 430 86th. The next door neighbor, believing it was theirs, removed all of that. That's the only growing plant material on the property that I know of that's ever been removed. And what's interesting is that if you look at the property now, their mailbox is about 2 or 3 feet in on my property line because it was in line with where that covering was, but it wasn't me. The other thing is it says that I replaced, and I guess it's the problem that I have is with the word all. It says you have removed all vegetative ground cover. It doesn't say from the front yard. The implication is it's from the whole lot, and that's just not the case. And that can be verified because when you go online with the city's online information about the case, it admits that it's only a part of the backyard and not the entire property. So I feel like that should be recognized. The other thing is that I didn't replace the entire lot with pea pebbles. It is all of the front yard, but it's a portion of the back, and that there's some pre-existing. I can't tell you how much, but there is some pre-existing non-vegetative ground cover in the backyard that was there even before I bought the property. And so I don't know when this statute came about, but I can tell you that I wasn't aware of it. None of my neighbors were aware of it. My next door neighbor just did the same thing, and I'm not reporting him. I'm just saying that I don't think people know this. And I think there needs to be, certainly if I'd known it, I wouldn't have done it, and I wouldn't have, lost a fair amount of money on that, or about to. So I think that the documents that I've shown in my testimonies that I'm cooperative with the city, I thought I was under a extension. The first opportunity I had to realize I may not have been under an extension was when my neighbor sent me a copy of what was posted on the door. And they said, hey, you should probably know about this. So that, I guess, was the second time that I was caught off guard by receiving a notice from the city. And it was really, it came about, I guess the notice was done on the same day that I had gotten my contractor bid on the proposal. So I don't want to drag this out. I want a resolution. I live out of town, and I don't want it to be a problem, but I need to be able to sit down with somebody with either the planning or somebody on the staff that says, listen, we'll agree if you do this, this, and this, you know, either by way of a variance or whatever it might be, we'll agree with this resolution, and then I can move forward. And I don't know how long it takes to do that. I have made some efforts to do it, but those were unsuccessful and unresponded to. So I guess I'm asking for a little bit of help here.
Okay. Any questions from the city? Oh, and first of all, any objections to any of the exhibits?
No.
Okay.
The only question I did have is I don't know the date of this first picture.
That was taken off.
You said this is,
Yeah, it was taken off of the web, and I didn't have a photograph of it either. It's a representation that I screenshot off of Google Maps. So if you go to Google Maps and you look at the street view, you should be able to see that same picture. And on that, it says about a year ago.
So
I can tell you as a testifying witness that front lawn has looked like that for at least 3 years. It's been at least since COVID that it's looked like that.
okay. Any objections to any of the exhibits?
no, I don't,
Then the exhibits will all be accepted.
that's fine.
Any questions from the city?
Not questions. If Madam Magistrate wants me to make arguments on the notices, I think it's clear that we cite the correct provision. Property owners here, most of his testimony to the city's point of view, I think he could work with the city offline. I think what we're here today is to find him in violation of 22.4 based on ground cover and impervious surface. I have the city's planner and community development director here if she wants to. Madam Magistrate wants her to attest to what is required, but working with the city is something that we're willing to do.
Well, I would like to hear from Mr. Cruz with regard to the extension that was requested from the respondent. I do see that the email doesn't directly, quote, grant an extension, but the testimony is that the telephone conversation, there was an agreement that there would be an extension. Mr. Cruz, were you under the same assumption that there would be an extension past the date in the notice of violation?
Yes, that's why I wrote in there received, because we had a phone conversation, sometimes a little bit more detailed, so I do apologize. Maybe I could have been a little bit more detail in there. But to our phone conversation, I'm giving you an extension, but just like the email stated, and as you've seen, he reached out on the 20th, and I haven't heard from him since. He hasn't reached out to me to let me know about his workings with the contractors, and even the phone call to Kristen Coleman, my director, and our planning and zoning official. If I would have known he reached out, and she gets a lot of phone calls. She deals with a lot of things, so she just might have missed it. So if he would have gave me a heads up, hey, I tried to reach out, I'm trying to come into compliance, could you help me kind of get in touch? I would have no problem helped him to get this resolved, so we didn't have to be at the point that we're at now. But I did give him an extension in per se past the compliance date because you reached out and I thought we were working towards compliance. That's why I said stay in communication, just so I know that you're doing what he showed here today but didn't show to me.
Okay. And you said you had someone here in the planning department?
Yeah, we have Kristen Coleman herself, the community development director.
If you could please come up and have a few questions for you.
Good morning, Kristen Coleman, Community Development Director and also Senior Planner.
Good morning. Do you recall, or did you, before this hearing, look up to see if you received an email from Mr. Dillon?
While I was sitting here, and no, I did not receive an email from Mr. Dillon.
Okay. And we did and Mr. Dillon, what you provided was the email that was sent, correct? Phone call. Okay. Do you recall receiving a voicemail from Mr. Dillon, or were you able to look to see if you received a phone call from Mr. Dillon?
From here, I was unable to look. However, I do on my voicemail leave my email address. Usually that's, if you can't get me by phone, that is the best way to get me. And also there is that paper trail as well. I know he did submit a documentation that was sent to the mayor. I am the person in charge of variances too, so I did not receive any direction or any forwarding of that information, so.
Okay. And then another question, it appears that in the code there is an administrative process that's not typically not a variance per se, as there's no direct criteria, but allows for administrative approval. What you saw here presented today with the pea gravel, is that something that might be considered for that type of administrative approval, as it is as it is a pervious surface?
No, unfortunately, I don't think it would qualify for something administrative. It usually something is called for innovative. We usually work with like a landscape architect, some kind of water garden, something to that. I don't think that's really what was reflected or shown as part of that kind of a design work for that. And just looking at the numbers, and unfortunately, I did not have a survey on file, but just by looking at dimensions and square footage from the property appraiser. So Mr. Dillon's property is about 6,500 square feet. So to qualify for the 30% ISR impervious surface ratio, he would have to maintain, let's see, that would be around 2,000 square feet for the to equal the 30%. And for the vegetative, or 24%, which we require, is 1,600 square feet. So looking at the square footage of the pebbles or rock or whatever would be limited to around 340 square feet total. So I kind of did those numbers really quick just based off the numbers provided. But had Mr. Dillon perhaps forwarded me Murphy's land surveying, we could look at the numbers. I'm more than happy to sit down with him and go over that to say, here's your amount that you're allowed for that. But a permit is required. So from the beginning, had a permit been submitted for review by our planning staff, we could have acknowledged and reviewed compliance with the land development code.
Okay, so what you're saying is a permit is required for changing out landscape on your property?
Yeah.
Okay. Okay, I don't have any further questions. Mr. Dillon, do you have any questions for the planner?
I don't, but would like to work with you to try to find out a resolution. I think there's a way to mathematically get to what I'm entitled to, and what I'm sort of hoping to do, given everything that's happened, try to find something through a variance I may not be entitled to, but something the city can live with, is an appropriate resolution.
And that's something that might be able to be done offline, so.
Absolutely.
Okay. Mr. Dillon, do you have anything further in support of your defense?
Yes, I do. I definitely don't want to be sideways with the city here. I want to work out a resolution. I think it's clear that I did try to do that. I guess I could have called Mr. Cruz weekly. I didn't know how. It didn't say how often and frequently I would have to keep him updated. I read the email as such that once you have sort of a plan or a resolution, call me about it, and that's what I was planning to do. I got that bid. I couldn't really commit to something without knowing what the cost was going to be. I received that on the same day that the notice was issued. So, for me, I feel like I shouldn't have discovered that I wasn't on continuance anymore by receiving a notice of a hearing in front of a special magistrate. So the other thing I would note is that the photographs that the code enforcement officer offered are in-process installation. This was all done in a day. And I think some of this could have been stopped by just telling the landscaper, hey, this isn't permitted. You're not allowed to do that. Or contact somebody, because clearly it was a work in progress at the time that the photographs were taken. And so, I just want to get it resolved, and I would ask Special Magistrate to allow me sufficient time to do that.
And what do you think sufficient time to have resolution would be?
Well, it sounds like I have to go through the permitting process in order to do that. It also sounds like it would be an after the event permitting, because I already have something that the city believes is not compliant. And so I just don't know. I've never been in that situation before, so I don't know what the extension would be. But I live out of town, and so I flew down here. I've taken all of this very seriously. I flew down here to appear before you today to make sure that my side was told. I'd like to avoid having to come down again if we're being able to work towards a resolution.
Okay. Anything from the city, further from the city?
No, I just have a question. You said you received the quote from the landscape person the same day that you received the notice of violation. Did you send any of that to the city? Any of that information?
So
kind of informing Lewis that you were working and getting quotes, or was it just that one email and you kind of left it alone?
So I told Mr. Cruz that...
Yes or no is fine, if you don't mind. Did you send it? Yes.
McConnell, he is entitled to explain his answer.
Yeah, it's inaccurate. Your question's inaccurate. I never said that I got the quote on the same day I got the notice. I didn't get the notice until several days afterwards. It just so happens that the notice and the contractor's quote is dated the same day. So I can't answer a yes or no question to something that's inaccurate.
Did you send the quote that you received to the city?
No, because when I got the quote, I was going to prepare something, and by then, it was a couple of days after I received this hearing, and I felt like, well, I better, this is my opportunity to come down and explain it to the city.
Okay.
Okay, based on the evidence that was presented here today in the testimony, I will say it looks like both parties could have done a better job at communicating. And while I appreciate, Mr. Dillon, that you didn't know what the status of the law was, when you buy property in a jurisdiction, ignorance of the law is not an excuse. You are also a practicing attorney, albeit not in the state of Florida, so, you need to be aware of the zoning, the land development laws, that type of thing. I know it seems like maybe landscaping isn't something that would be regulated, but every town has its own regulations. And as you said before, you've owned property in St. Pete Beach since 2008, albeit not this property. So with that being said, I will find that there is a violation of the stated code section. I am going to allow for 30 days for you to work with the city, gather the required permits. You said that you've already got your quote from your landscaper and that they're ready to go as soon as kind of you give the go-ahead. Understanding that you're working from out of town, I think the 30 days should be sufficient. If within that time period there's an extension of time that's needed as you've been working in a good faith effort, then certainly you can work with the city on that. But other than that, I will set this case for a status hearing on May 13th. Hopefully it will be resolved by then and I won't need to see you again, but if so, then we will see you again on May 13th and I will get you an order to that effect.
Okay, thank you.
Okay, moving on to the next case. Case number 2024-0167, City of St. Pete Beach versus Stalba Investments LLC. Mr. Rivera?
Yes. Stephen Rivera on behalf of the City of St. Pete Beach Code Enforcement. Case number 2024-0167, respond to Stalba Investments LLC. Violation address is 4215 Miller Drive. Violation description, the property is in violation of 8.2A, permitted principle and structures of the Land Development Code of the City of St. Pete Beach. Case summary, initial inspection 3/18/2024, irreparable and irreversible notice of violation dated 3/18/2024, notice of hearing dated and posted to the property 3/18/2024. The following is a true and accurate representation of what I witnessed. This is the affidavit of posting. This is a definition for transient occupancy. It's a picture of the property at 4215 Miller Drive. This is the Airbnb listing that was on the property. This was on 3/18/2024. This shows the 2 reviews for the short-term rentals. It shows 6 days on one side and another one within a week. This was on 3/18/2024. Corrective action. Property can only be advertised and rented as a monthly rental. The property has removed the Airbnb listing. Recommended fine is $1,000 per violation for the 2 reviews, plus $325 administrative costs. And we do have a copy of the Airbnb review policy.
Okay. Okay.
Madam Magistrate, may I
Yeah, and I have
go
a...
back to the reviews?
Yeah, I do have a question, though. I know Airbnb and VRBO's review policies are different. Mr. Rivera, can you point to me somewhere in the Airbnb review where it specifically states that if there's a time period with which you need to review within whatever the date of your stay is? I know VRBO's is, I believe, you must review it within 7 days, and they list the actual dates of stay. Well, I see that your evidence says 6 days ago and 1 week ago. I'm not sure when those stays were. That just indicates when. I actually don't know if that indicates the stay or if that indicates the review date.
And I'm not seeing it expressly stated in here. We're still reading through it.
Okay.
So
while he's
if-
doing that, Mr. McConnell?
Well, if I may, Mr. Rivera, can I see that policy? And then I was going to actually make a suggestion. Can you go back to the reviews? And then if Madam Magistrate, once I make my point, if you're okay with hearing from the respondent while I find this, or would you prefer?
No, that's fine.
Because I do want to make a point on the reviews. Go back to the PowerPoint, please.
PowerPoint, please.
So while we review the policy for the time frame, right, 6 days ago, stayed 1 week ago, if you notice on the left when it says stayed a few nights.
Right. My concern is with the other one.
Correct, correct. So at a minimum, I do want to say the city would ask for $1,000 for that one because that clearly is a less than 30-day rental. Okay. What is she looking for specifically? It's the wrong policy. Okay, you can hear from the respondent. We have to print a different, it was a different link, yeah.
Okay, is anyone here on behalf of the respondent, Stalba Investments LLC? If you'll please state your name and affiliation with the corporation for the record.
Oh, sorry, not the other, code enforcement, that was confusing. Sorry.
And do you would like to present a defense to this?
Yes. What I did, once I got the notice, advised with my attorney, told me exactly what I needed to do. We took down the advertisement right away. As soon as we were issued, we canceled any reservations that we had. And, you know, my attorney reached out to Mr. Rivera to make sure we were in compliance with everything. At the time when we did this, I didn't know we couldn't Airbnb it, which, you know, I know people that are doing it. I assumed I could do it when I purchased the property. And, you know, as soon as we were notified, I did everything that I could do to get into compliance so we wouldn't have a problem.
Okay, and the two reviews that are posted, do you know if those were both stays that are less than 30 days?
I don't host it, so I'm not sure.
Okay, have you had any stays that have been more than 30 days?
No, I got it out now. We're advertising.
Okay. Do you have any questions for the respondent?
No, I mean, we can show this on the overhead because we can't print it, but there's a 14-day similar policy, if that's okay.
I don't think that I need it based on the respondent's testimony.
I agree. But for the next cases, if you guys could. So the city's point is you can't, The advertisement, we appreciate you taking it off and you're compliant there. The city's point of view is you can't correct a rental that already occurred, hence the irreparable and irreversible nature of this violation, which allows us to charge more than $250 per violation. That being said, at a minimum, the city, with the one comment on the left, which clearly designates stayed a few nights, would like to impose a $1,000 fine for that plus admin cost. Based on the respondent's testimony, if he has not rented it for longer than 30 days, I believe we can assume that the one on the right was for less than 30 days as well. But I will leave that up to Madam Magistrate.
I misunderstood what was being asked of me. I thought you asked if I rented it, previously for longer than 30 days.
Yes.
I don't know how long she had that rented for. I'm not sure. I don't host it. I'm just the owner of the property. I have somebody that takes care of the property.
Okay, ultimately, okay, so you don't have that information.
My decision was to take the advertisement down and get it straightened out right away, so I didn't have any problems. And that's what we did.
Okay.
And Mr. Stalba, how long have you owned the property?
I probably had it 5 months,
5 months.
6 months at the most.
Any other questions from the city? Anything further, Mr. Stalba?
No.
Okay, I'm gonna say the same thing that I said to the previous gentleman. You did assume, but when you purchase property in a jurisdiction, you're responsible for knowing what the laws are, even if your neighbors are violating the law. Just because somebody else is speeding doesn't mean you should be speeding, all that kind of stuff. That being said, I've not seen you be here before. I am going to find that there is a violation. I am going to find that it's irreparable. I am only going to assess a $500 a stay fine. I do find that, well, a $500 a stay fine, and I do find that the evidence on the record suggests that only one of those, for sure, was a short-term rental. But the Airbnb policy does state a 14-day window from the date of the stay. And there were two that were within, one was posted a few days, 6 days, and one was posted a week, so they were back-to-back. That is two within a 30-day period. So I'm going to find $500 fine per stay, which is $1,000 total, plus administrative fines. There is a provision in the code that allows you to come back and have those reduced if you so choose. But I will get you an order to that effect, and make sure we have your email address or your mailing
Well, I'll
address.
ask you a question. What's the chances of having it reduced?
You'd have to come see me again.
Correct. There's a policy. You can meet with code enforcement and we can give you the application, and it's a whole different.
Excellent.
Yeah. So if you want to leave your email down there, if you hadn't.
Yeah, it's on.
And I will get you an order to that effect, Mr. Stalba.
All right.
Thank you.
Okay, moving on to case.
Madam Magistrate, if we
Yes.
may, can we take like a 3 to 5 minute break? Do you mind?
Yeah, let's come back at 11:25.
Okay, thank you. Go. You guys don't listen.
And we are back on the record. Moving on to case number 2024-0148, City of St. Pete Beach versus Harley Schrock. Mr. Rivera.
Yes. Stephen Rivera, City of St. Pete Beach Code Enforcement. Case number 2024-0148, respondent Harley Schrock. Violation address is 220 45th Avenue. Violation description, the property is in violation of Section 9.2A, permitted principle and structures of the Land Development Code of the City of St. Pete Beach. Case summary, initial inspection, 3/12/2024. Irreparable and irreversible notice of violation dated 3/12/2024. Notice of violation hearing dated and posted 3/12/2024. Following is a true and accurate representation of what I witnessed. This is the affidavit of posting. Definition for the transient occupancy. This is the property here at 220 45th Ave. Airbnb listing. This is just the host information. Showed it was a minimum stay 7 nights. And here we have a couple of reviews. There was one for January 2024, December 2023, another for December 2023, another for January 2024.
Can you please submit the Airbnb policy?
Airbnb policy. The corrective action, property can only be advertised and rented monthly. The property has removed the Airbnb listing. Recommended fine is $1,000 per review, plus the $325 for administrative costs. We have the Airbnb policy, review policy. Go right, please.
Okay.
So,
Thank you.
Mr. Rivera, do you mind going back to the PowerPoint real quick for the comments?
Yes.
Before we move on. Oh, okay, never mind. The one I'm looking at online had the wrong one circled. I just wanted to be clear. We couldn't confirm or deny that the top left was in January, so the 4 that we're looking for are the 2 in January and the 2 in December.
Okay. I saw what I needed to see on that. Thank you.
Okay.
Anything else, Mr. Rivera?
No,
Okay.
thank you.
Anyone here on behalf of Harley Schrock? Okay, if you could please come state your name for the record.
My name's Harley Schrock.
Okay, and anything you'd like to say in your defense?
Yeah, I believe they have 2 weeks to leave a review. The first 2 reviews in December was late. It was October through November, like part of November, and then November to December 24th was the second one. The 2 in January, one was a friend and one was actually a neighbor. I wanted to get reviews up. Had I not known this policy, I wanted to get reviews up so I could use my place. So the 2 in January were short-term, but they were a neighbor and a friend. So yeah, I have removed the listing. I have spoke to Mr. Rivera, and I'm not renting it at all. So that is my...
Okay, any questions of the respondent, Mr. McCollum?
I do just have a, can you explain the December? So you're saying that one of them was from October to November?
November 22nd.
And it started October?
20th.
Okay, and then the next one was?
November 24th through December 23rd.
Okay. I don't have any questions. I just want to clarify that nothing in our code designates any exemptions for family, friends, or anything. And the fact of the matter is a short-term rental, anything less than 30 days is classified as a transient rental pursuant to the definition in 2.1.
And I'll just, one thing, again, you've said it a couple times today, I appreciate learning that, like, this is my first time owning a property down here. I didn't know, the person I bought it from. They said they did that, they rented it for that, I bought it, wasn't planning on it, needed to do it, obviously for financial reasons. So anyways, that's it. I appreciate your time.
Sure, I did have one quick question, Mr. Schrock. On the two that you said was the family and your neighbor, did either of those people actually stay at the property, or you just had them write reviews?
No, they stayed.
They actually stayed,
yep.
okay. And did they pay you for those stays?
One did, one didn't.
Okay,
Yeah, my neighbor had family coming in, and they gave me we did like a special thing.
Okay.
I could get a review. It was very, very cheap.
sure.
but
And
yes.
did they stay for less than 30 days?
Yes, ma'am.
Okay. And then your family that stayed, can you describe what the
It
situation?
was a friend. It was
Oh,
a
a friend.
Yeah, yeah.
Okay, and you guys didn't exchange anything for staying there? Okay,
I had to do it for $1, so I guess we did. I had to do a special, so I'm telling, yeah.
so that you could get the review?
Exactly.
Any other questions from the city?
No. Mr. Rivera, can you just bring up the definition of transient occupancy one more time? I just want to emphasize, and I understand Madam Magistrate's questioning, but the last sentence, and without regard to whether the right of occupancy arises from a rental agreement, other agreement, or the payment of consideration. So I just want to make that clear. Don't have to be paid in order to have a transient rental.
Notwithstanding the problems with allowing family to stay at a place without exchanging money, I do see that definition, and I understand this is an equitable proceeding. I am going to find that the property was in violation. However, I am just going to find for the two properties, or the two stays, obviously because the first two, there's credible evidence to suggest that they fall within time frame of the 14 days, that they were longer than a 30-day, or that they were a 30-day rental. For the other two, understanding one was a neighbor, that was actually a short-term rental, because you said you exchanged money. The second one being the friend, $1. I understand you just want to get the reviews. I am going to find that both of those are irreparable violations. On the friend, actually on both of them, to stay consistent, I'm just going to do $250 each. So for a total of $500. You've said that you've stopped.
Yeah.
If I do see you here again, I likely will not be so lenient. So, but I do understand your situation, and I appreciate the credible testimony. But like I've said to everybody else, you buy a property within the city's jurisdictions, you need to know the laws. So, and I will get. And you guys asked for $325 of administrative
I was just
costs.
about to ask. Yes, ma'am. Admin costs.
And $325 in administrative fines or costs. And I will get you an order to that respect. Make sure we have your email address or your address so that we can.
And
use
Mr.
it.
Rivera's been in good contact. We've had some good conversations, so it's not a problem. I appreciate it.
Appreciate that.
Thank you very much, Mr. Schrock. Okay, moving on to case number 2024-0186, City of St. Pete Beach versus Larry B. Garner. Mr. Rivera.
Yes, ma'am. Thank you. Stephen Rivera on behalf of the City of St. Pete Beach Code Enforcement. Case number 2024-0186, respondents Larry B. Gardner. Violation address is 2815 Pasadena Way. Violation description, the property is in violation of section 20.03B, permitted principle and structures of the Land Development Code of the City of St. Pete Beach. Case summary, initial inspection was 3/25/2024. Irreparable and irreversible notice of violation dated 3/25/2024. Notice of hearing dated and posted on the property 3/27/2024. Following is a true and accurate representation of what I witnessed. This is the affidavit of posting. Definition for transient occupancy. This is the property at 2815 Pasadena Way. the listing on Airbnb. Host information. So the Passive Grill area is allowed to have 3 within a 12-month time period. Transient occupancy, short-term rentals. And then after that, it would have to be monthly. So this shows 3 here for May of 2023. And then there's June of 2023 is the first one. Two, 3, and 4. 5, 6, and 7.
So these are a little out of, can you go back? I just want to help clarify. Go back to the beginning, please. One more. Okay. So it is our position that Valerie, Kathleen, and Robert all stayed in the month of May based on the review policy, and those are their 3 for the year. Next picture. Next picture, thank you. So then we have 1 in June, Rachel, next, because Valerie and Kathleen have already, correct?
Said, right.
Next. Okay, so then you have Guy and Christy also in June, so that's 3 in June. Now you have Reba in July, next picture. Then you have William in July, so that's 2 in July. Then you have Mark and Anthony both in August, so that's 2 in August. Can't see that name, but we have 2 in October and 2 in September. Two in November. And mind you, these say stayed about a week, stayed a few nights. Airbnb's policy, they now designated the stay.
And correction, the number 13 should probably be omitted. It was.
It's a response.
Right, it's the response from the property owner.
Got that. 3 in January. Stayed about a week, stayed about a week, stayed a few nights. 2 in February, stayed about a week, stayed a few nights. Can you go back one?
Yes.
So that's Katie and Rosanna. Okay, can you move forward? So we have 4 in February, because you have Kate and Lindsay at the bottom. It is our position that Brenda and Linda were short-term as well.
Yeah, it says stayed about a week, stayed about a week.
Correct. Next picture. Okay.
So the corrective action, property is permitted to only have 3 short-term rentals within a 12-month time period. All rentals after must be monthly. Property is eligible for short-term rental March of 2025. Recommended fine, $1,000 per violation. I believe it should say 22 reviews, plus the $325 administrative cost. That concludes my presentation.
And is the city submitting the Airbnb review
Yes.
criteria as well? Okay. Anyone here on behalf of Larry B? Oh, I've seen it. I will take it into the record.
Okay.
Anyone here on behalf of Larry B. Garner? Could you please state your name and your affiliation with Mr. Garner?
Yes, my name is Mary Wesley Garner, daughter of Larry Garner.
And do you have permission from Mr. Garner to speak on his behalf?
I do, a power of attorney here. You need to see that.
If you could just put it on the overhead so that we can.
Mary Wesley Garner here.
Okay. Thank you.
Mm-hmm.
And anything in your defense, Ms. Garner?
I've none other than I'm new to the Airbnb situation. I was trying to grow that to be a success. However, At the same time, I was not aware of the 3 and not 30-month stays. So as soon as I received the official notice, contacted Airbnb, contacted Mr. Rivera, and let him know that short-term stays are no longer. And so I've updated on the app that only, I believe he had said 28 to 30 days. Monthly. That's the minimum night stay. So no more of the short-term stays unless it's within a 12-month period. But after all this, I don't even know that we'll do any short-term stays at all. I can't say that they didn't stay because they did stay, but I wasn't aware of that. So from the cases I've heard before, I know that it's our responsibility to find out the zoning. I did not think that there was a problem with doing that, or else I would have never had short-term stays at all. It is something to simply supplement income to help kind of with things around the house. I've sort of changed some things in my career to help with my father's stuff, so we were just trying to increase some income. So sadly, this is going to be something that I don't even know how to understand how to pay for the fines of things like this, but just know moving forward that, short-term stays are not going to be tolerated there. Airbnb, I didn't know if it's purposeful or whatever, but Airbnb, I was contacting them, let them know, and showed them the notice, and they actually, on behalf of Airbnb, canceled the short-term stays. Okay. So I don't know if you need that or not, but I have a whole listing of our.
Well, I find your testimony credible, so I won't do that unless.
I just thought it would be, they were glad and were nice to hear of the situation, and no more short-term stays will be there. It doesn't even have to be there at all, but it was something that I was trying to help out the family with, so.
Okay. Any questions for Ms. Garner?
I do have one question, if you can answer it. How much did you make from June of last year till now, roughly, from these rentals?
I don't know offhand of how much June of last year until now.
Yeah.
I'm sure there is a way to look this up in the app, but the stays were potentially, I think there was $275, $285, and then just recently over the Christmas time was able to rent for $310. So okay. It was a considerable amount, but not as much as one may think with the expenses and things of helping to kind of pick up.
Understood.
From my dad's stuff. So
to clarify that, were you on each of those rentals, would you say that you made in excess of $1,000?
On each of them, I wouldn't say each.
Or on average?
Potentially, some of them, if they were, I don't know, longer than 3 days, potentially we could make 1,000, but normally they're in the 5 to 7 range. If it's a longer stay, I think we've reached 1,000. If they're 30-day stays, it's more than that, of course, but there was a discount to try to get people to stay longer.
Longer periods of time, okay.
I would prefer people stay longer anyway if we did it, because it's more headache than it turned out to be worth.
Okay, anything further, Ms. Garner?
No, thank you.
Okay, anything further from the city?
No, I would just request, I appreciate you proffering the cancellations, but in the order, if you could, if we could just get that email that you've canceled the future ones, I think that would be helpful for the city.
Absolutely.
No, nothing further. I counted 23 based on the evidence.
23, I counted 22.
Yeah.
So
the one review.
I mean, we can, 22 is fine, but I have 3 June, 3 July, 2 August, 2 October, 2 September, 2 November, 3 in January, 4 in February, and 2 in March.
I guess one question I could pose or ask would, since at the immediate notice of any type of, official violation that was posted, you know, there was immediate action taken right after that. I don't know that I have seen any notification prior to that. If I had, I would have
Right, so the issue that,
annihilated that.
right, so the issue that we have with these notices, with the notice of violation that you received is that the city is contending that they're irreparable or irreversible, meaning that you can't go back and fix what's been done. Which, if it's an advertising issue, you can take down your advertising, et cetera, but the fact is, these people have stayed. They did a short-term rental, they were there for less than 30 days, and unless we have a time machine, we can't go back and reverse that. So to stay consistent with my rulings, I understand that this is an equitable proceeding, so I am allowed to take in to a lot of things other than just the evidence. I am going to find that you are in violation of the stated code section. I count, by my count, 22 violations. So I am going to assess an individual fine for each of those 22 violations in the amount of $250. There's a like I've said before to other people, there's a provision in the code that you can come back, ask for a reduction in fines, or to contend with that lien. So I would suggest taking a look at that if you feel so inclined. But $250 for each of the 22 stays, and the $325 in costs to the city. I will get you a written order to that effect if you just make sure that we have your email address or your correct address there.
Okay.
All right, thank you, Mrs. Garner, or Ms. Garner.
Madam Special Magistrate, Pete Doerr, Code Enforcement Manager on behalf of the City of St. Pete Beach. Are you saying 5,500 plus admin?
I did not do the math on that, so if you're saying 22 times 250
Yes,
is
ma'am.
5,500,
Yes, ma'am.
I would have to consult my calculator, but that sounds about right.
Thank you.
But I am not under oath, so don't hold me to that.
Yes.
Moving to case number 20240158, City of St. Pete Beach versus Thomas Drumgel. I apologize if I messed that up, and Caroline Zaleski. Ms. Rivera.
Stephen Rivera on behalf of the City of St. Pete Beach. Case number 20240158, respondents Thomas Drumgel and Carolyn Zielinski. Violation address 3208 East Maritana Drive. Violation description: the property is in violation of section 9.2, permitted principle and structures of the Land Development Code of the City of St. Pete Beach. Case summary: initial inspection 3/14/2024. Irreparable and irreversible notice of violation dated 3/14/2024. Notice of hearing dated and posted to the property 3/18/2024. Following is a true and accurate representation of what I witnessed. This is the affidavit of posting. Definition for transient occupancy. It's a picture of the property at 3208 East Maritana Drive. It's the Airbnb listing. And so we're looking for, this is the review for November. Based on the review policy, this was the violation that we see stayed a few nights in November.
And the top two.
I'm sorry?
So November says stayed a few nights, which in itself, I think shows proof of short-term rental. The top two, based on the review policy.
Correct.
Okay.
Based on the review policy, it could
Yes.
be within that 2-week time frame.
Right, so explain to me the math on the top two, how you find that those are both short-term stays.
We're not, we're just the one that's.
Well, Mr. McConnell did say the top two,
The
you
top
not?
two,
or did I mishear that?
yeah,
Okay.
this, going back and looking at it based on the review policy, it could be within the 2 weeks. We don't have proof for those two, so
Okay.
that's not what we're seeking, just the one that we
Just
can
the
prove.
one in November?
Correct. Corrective action: property can only be advertised and rented as a monthly rental. Recommended fine is $1,000 per violation, the one review, plus a $325 administrative cost. And that concludes my presentation.
Anyone here on behalf of Mr. Dromgoole and Ms. Zelinsky? Or Zaleski? Anyone here on behalf of the property owners, Thomas Dromgoole and Carolyn Zaleski? Mr. Rivera, have you had any contact with the property owners at all?
I have not. No, the only people I spoke to were the renters that were at the property. They said they would give her the information as well, but we did mail out and post the property.
Okay. Okay.
Can I ask a question?
Yes.
Out of curiosity, so there was renters at the property when you served the notice?
There were, and they were there for they were staying for 4 months.
Okay.
When I talked to them.
Thank you.
Okay. All right, based on the evidence presented, I am going to find that the property was in violation of the stated code sections. It is an irreparable, irreversible violation. I will assess a $1,000 fine and $325 in administrative costs.
Thank you.
Case number 2024-0187, City of St. Pete Beach versus Thomas D. Parker and Phyllis Parker. Mr. Rivera.
Thank you. Stephen Rivera on behalf of the City of St. Pete Beach Code Enforcement. Case number 2024-00187. Respondents Thomas and Phyllis Parker. Violation address 3611 Casablanca Ave. Violation description: the property is in violation of Section 9.2A, permitted principal and structures of the Land Development Code of the City of St. Pete Beach. Case summary: initial inspection 3/26/2024. Irreparable and irreversible notice of violation dated 3/26/2024. Notice of hearing dated and posted to the property 3/27/2024. Following is a true and accurate representation of what I witnessed. This is the affidavit of posting. Definition for transient occupancy.
Ms. Rivera, can you go back? That definition of transient occupancy says more than 3 times in any consecutive 12-month period, but the violation says that in the R2, they cannot rent at all for less than 1 month. Is that correct?
1 month in the RU1, RU2.
RU2?
Yeah,
Okay.
the only place that has the 3 would be the Paso Grove.
Paso Grove. I just wanted to clarify based on what's in the record. Okay.
This is the VRBO listing. So the reviews here shows 10 nights in February of 2024, 7 nights in February of 2024, and then 7 nights again in February of 2024. Corrective action: the property can only be advertised and rented as a monthly rental. Recommended fine would be $1,000 per violation, 3 reviews, plus $325 administrative costs. I do have a copy of the review policy for VRBO.
Okay, that will be accepted into the record. And if you could just, I mean, I don't think I need it because the reviews explicitly state when, how long they stayed.
Okay.
But that will be taken into the record.
Thank you. Now, I do want to clarify, we're going 1,000 per review. However, if the magistrate, if the respondent would like, and we can always do $250 a day per night as well. So I think we're being fair with saying 1,000 per comment, but the reality is we could go $250 a day per each night because you can't rent it at all for less than 30 days.
Understood. Okay, anything further from the city?
Oh, man.
Okay, anyone here on behalf of Mr. or Ms. Parker? If you'll please come up, state your name and affiliation for the record.
Phyllis Parker.
Okay, and Ms. Parker, what would you like to say in your defense?
I've owned the house since 2020. It's clearly listed. VRBO, I thought it was the same as Airbnb in the listing, but on my listing on Airbnb, it explicitly says 30 days only, and I have never rented under 30 days until those 3 incidences. And the reason I did is because I thought that the law had changed. I think it actually has changed, but it's not in effect until July.
That's debatable, but okay.
Okay, so, and the notice was given on March 27th for February incidents. Why not say to me, hey, you're violating the law on the first incident instead of waiting till the end of March to put a notice on a door? I don't live at the house, and so I just was lucky to get that notice because a neighbor saw the notice and said, hey, there's a notice on your door and you have to appear in court. I called Mr. Rivera on the 28th asking for an extension, and I was told I couldn't have an extension. And it was Easter, my father-in-law died. I had a lot of reasons to be able to get an extension, and I was denied. I don't know what I would have done otherwise, but it seems to me if you're going to violate a person, why not violate them in the beginning instead of waiting a month to have 3 violations instead of 1 violation.
Okay. Any questions for the respondent, Mr. McConnell?
No questions.
Anything further, Ms. Parker?
No, ma'am.
Okay. I will let you know from my point of view, notice is notice. So I don't take into account when the city gives you notice, whether it should or shouldn't. Legally, they're required to give you notice. I don't know when they found out about it, and even so, they only have to give you the legally required notice under Chapter 162. So
is that not they don't mail a certified letter? The only notice I got was this piece of plastic on the door.
So then that is a fair question. If you'd like to ask the city, I would do the same, since you're contending that there was insufficient notice. However, all that being said, you can certainly make those arguments. There's counter arguments in case law to support that. Because you are here today, those kind of arguments are not necessarily waived, but hold less water because you are here, you've been given appropriate notice, and you are defending your case. But I would, to your point, I would like to hear from Mr. Rivera if the notice was sent per Chapter 162 via certified mail.
Yes, so we sent the notice certified and posted the property, and due to it being irreparable and irreversible, there's no cure time. The violation is the violation.
Correct. So, but a certified mailing was in fact sent out.
Yes, ma'am.
Okay.
There's a certified letter in the mailbox at the address, and I didn't get it at my address in Indiana, so I didn't receive a certified.
And I see here, Ms. Rivera, it looks like the notice went to 3611 Casablanca Drive.
With someone property appraiser, we sent it to the mailing address through Pinellas County Property Appraiser.
Which, to your recollection, is 3611 Casablanca Drive.
Correct.
Okay. And Ms. Parker, is that where your tax statements go to? Is that to your understanding, is that where the
City taxes?
your property appraiser's website has that address listed as the property owner's address?
Yes.
Okay. Okay. Anything further, Ms. Parker, in your defense? Okay. Anything further from the city?
No.
Okay. Based on the testimony here today, Ms. Parker, I understand that you thought the law had changed, but you were in compliance. You put yourself out of compliance, and it wasn't from ignorance of the law. It was just that you started a short-term rent, and from your testimony, you had it on one site and not on the other. So I am going to find that there is a violation. I am going to assess $1,000 per violation, or at your option, $250 a day for each of those stays. I don't do the math, so.
That would be $6,000.
So $6,000 for the $250 a day, or $1,000 for each of the 3 incidents. So would you prefer the 1,000? I don't usually ask the respondents, but which one would you prefer?
I have to pay more. No.
Yeah, I figured as much. So I am going to assess a $1,000 a day fine plus the $325 in or not a day, $1,000 per occurrence fine plus the $325 in administrative costs. And like you've heard here today, there are ways to come back and ask for a reduction if you so choose. But make sure we have your address or email address, your correct one, to get your notices to, so that I can send you a copy of this order.
All right.
For this one, could we also request we be provided proof?
I will do the standard order that I had always done on the short-term
Correct.
rentals, that proof that all cancellations of any future short-term bookings have been, and this one does not fall within the 3 per year, so there will not be a,
Correct.
it will just be that it needs to cease immediately and only be rented for 30 days. Okay, thank you, Ms. Parker. All right, case number 2024-0147, City of St. Pete Beach versus Tyler Rochot and Natali Rochot. I am so sorry. I know I'm butchering people's names. Mr. Cruz.
Yes. Thank you, Special Magistrate. Code Enforcement Case Number 2024-0147. Respondents Tyler Rochot and Natalie Rochot. Violation address 460 59th Avenue. Violation description. The property is in violation of Section 8.2, Permitted Principal Uses and Structures, A, of the Land Development Code of the City of St. Pete Beach. Case summary. The initial inspection was 3/11/2024. Irreparable or irreversible notice of violation dated 3/12/2024. Notices of hearing dated and posted on the property 3/12/2024. And these are a true and accurate representation of what I have witnessed. This is the affidavit of posting at 460 59th Avenue, March 12th, 2024. And as you've seen previously, the transient occupancy definition, section 2.1. This is the Airbnb advertisement. As you can see, they have a minimum stay of 2 nights advertised and hosted by Natalie. Also in the description, first and last name. This is just a picture of where you can park while staying at the property for short-term rental. This is just a Google view of the property at 460 59th Avenue. Right, as you can see there, 2 weeks ago, stayed a few nights. 3 weeks ago, stayed with kids. 2 weeks ago, stayed with kids. 3 weeks ago, stayed a few nights. 3 weeks ago, stayed with kids.
Oh, Mr. Cruz, if you could just stop right there.
Yes, sir.
Based on, I understand we've been consistent, so without the month, I just want to point out there's one review here that says 3 weeks ago that stays a few nights, so that's number one. And if you can go back a page, please.
Yes, sir.
And there's one that says stayed a few nights, right? So we're only going after 2 out of the first 5 just because it doesn't designate a month. Even though I believe if you have 4 comments 3 weeks apart, it's clear that they overlapped and stayed for less than 30 days.
Let me get to February 2024. Then another one in February 2024. January 2024, January 2024, January 2024, which was Kitty. Shayna, December 2023. Melissa, December 2023. Grace, December 2023. Mariah, November 2023. Sam, November 2023. Elke?
November 2023.
Yes. October 2023, 1. October 2023, 2. Ashley, that's 3 in October 2023. Katya, August 2023. August 2023, that's 1. August 2023. Rebecca, that's 2. August 2023, the 3rd. Sarah, July 2023. Katie, July 2023, making that 2 in July. And I would also like to add, if you could put on the overhead, please. I would like to show that advertising has been changed. This screenshot was from 4/4/2024. It's a 30-day minimum. And a screenshot from this morning for 8 to add an additional one, which makes it 28, minus a few that we had talked about in the beginning, but what I totaled previously was 28.
Well, Ty,
That changes things a little bit, though.
It does,
Because the math
because-
is different on that, because now you've got 2 with 3 weeks ago and 2 with
well,
2 weeks.
not only that, all 4 of them say stay a few nights.
Yeah.
So, okay, so that's 1, 2, 3, 4.
I can show you another one as well. This one was
On the last one, go by name. On the PowerPoint you showed, did it have Benjamin and Andrew?
yes. So you would like me to go back to that one?
Well, you don't have to, but I just wanted to see where it started.
2,
Would that be a total of 29?
3.
1 second. Yes, it did. So what I said in the beginning has now been
Changed.
proven.
And
Yeah.
I can show one that's previous if you would like. This is from 4-4. That's
You
good.
can go back to the overhead.
Back to the overhead, thank you.
Yeah,
So by my, excuse me, so by my count, that's 28.
correct. That's what I have.
PowerPoint, please. And the corrective action. Property can only be advertised and rented on a monthly basis. Recommended fine is $1,000 per violation, totaling 28 reviews, plus $325 for administrative costs.
So the city is not going after the advertising for,
It's been corrected.
because it was corrected
Yes.
before the date in the violation. Okay. Okay. Anything further from the city?
No, ma'am.
Right, anyone here on behalf of the Roshaws, and I apologize for what I am sure is a blatant mispronunciation. If you could please just state your names and your affiliation with the property owners, if you are the property owners, for the record.
Yes, I'm Tyler. This is my wife, Natalie.
Hi. Do you guys have anything you want to say in your defense?
So the only thing that we were under the impression that, because like when we got the notice, it says like detached single-family dwelling, and it's not detached. It's like a room in our house. So we were under the assumption, and we talked to somebody and got false information, obviously, and they were like, "Oh no, that's only if you rent the whole house." So it's like part of our house. It's not detached. So I didn't know if that's different or if that means anything, but that's really the only thing that we were going off of. We thought,
Yeah, my understanding, and Mr. McConnell can correct me if I'm wrong, is that with the city of St. Pete Beach, it's per parcel.
okay.
And since it doesn't matter if it's detached or attached, it's all in the
Yeah.
same parcel.
The wording, I was just like, when I saw detached, we talked to a friend that does Airbnbs, they basically steered us the wrong direction, so. But we've
Okay.
never rented the entire house, it's always just been the room.
Sure. Mr. McConnell, any questions for the property owners?
No, it is per parcel.
Okay. I do have a question. I noticed on the advertisement, it says that you've been hosting for 7 years. Is that correct?
We had a house that my mom used to rent 7 years ago that she had for like 6 months, and then she had to move back to Miami, and she asked me to rent it for her, but we never even had anybody stay. We actually have one review from that one that I canceled it, and then they left a review saying like, oh, she canceled last minute, but there was never any activity there because we ended up just breaking the lease because she had to leave to Miami.
Okay.
We just kind of tried, and then it didn't work out, but nobody rented.
Okay. And this home, you said it's a room in your home. How long have you owned? It looks like it was a newly built home.
We just built it last year.
No, we built the add-on, so we bought the house 3 years ago.
Okay.
And then we built the add-on with like, for like a guest, like, if we have family come over, friends come over, but just for like money reasons. you
Okay.
know, we assumed because we're not renting the whole house, we were in the clear, but obviously not. So.
Okay. And I'm going to say that what I've told everybody else,
Yeah.
when you purchase a property within the city limits, then you are subject to those laws regardless of what your neighbors tell you or friends tell you. So, yes, and did you want to say something? Okay. Based on the evidence that has been given, you do have 28 short-term stays. They have the ability to charge you up to $5,000 per each of those. I am going to take the recommended $1,000 per stay, plus the $325 in administrative costs, And just like I told everybody else, there's provisions to come back and ask for a reduction. But, you know, this is, I take all testimony and I take the reasons why people do things because I do have the ability to have it be a little equitable. This, like you said, was just a way to make some extra money. So, well, I appreciate that you guys thought you were doing things the right way. It's always best to check either with a lawyer, I know we're terrible people, or with the city to make sure you can do what you're saying that you can do. So I will get you an order to that effect. Please make sure I have your email address or your proper address so that I can get that to you.
Madam Special Magistrate, Pete Doerr, again, is that 28 times 1,000?
We'll review the order.
Oh, I don't know.
She said 1,000 per review.
Per review.
Oh, thank you. Just wanted clarification.
It's okay.
Thanks, Matthew.
And my count is 28, so
Very good, thank you.
Same as ours.
what the record stands at. Okay, moving on to case number 2024-0185, City of St. Pete Beach versus Rebecca Jones. Mr. Cruz.
Yes, thank you, Special Magistrate. Louis Cruz representing the City of St. Pete Beach Code Enforcement. This is Code Enforcement case number 2024-0185. Respondent, Rebecca Jones. Violation address 8125 Boca Ciega Drive. Violation description. The property is in violation of Section 9.2, Permitted Principal Uses and Structures, A, of the Land Development Code of the City of St. Pete Beach. Case summary, the initial inspection was 3/25/2024. Irreparable or irreversible notice of violation dated 3/27/2024. Notices of hearing dated and posted on the property 3/27/2024. These are a true and accurate representation of what I have witnessed. This is the affidavit of posting at 8125 Boca Ciega Drive, March 27th, 2024. And as you know, the definition, Section 2.1, transient occupancy. And the Airbnb advertisement hosted by Becca, showing that you can rent on a short-term basis. This was a property that you could rent at the minimum one night. Showing about Becca, the property owner / manager. And 1 week ago, stayed a few nights. 2 weeks ago, stayed a few nights. 3 weeks ago, stayed with a pet. Just kind of showing you the overall reviews from the people that stayed. And that she responded as well. And if you could put on the overhead for me, please. As of 4/4/2024, you were still able to rent on a short-term basis at the property. It was still being advertised. And an additional review was seen this morning. Stayed a few nights, totaling 4. Go back to the PowerPoint, please. Corrective action. Property can only be advertised and rented on a monthly basis. Recommended fine is $1,000 per violation for reviews, plus $325 for administrative costs. And that concludes my presentation. Thank you.
Okay, and you said on 4/4, the advertising did or did not come into compliance?
Was not in compliance at the time of 4/4.
Okay, is the city now seeking a daily running fine for the advertising, or have you abandoned that one? I asked because you brought it up, but I didn't.
Correct. Well,
take corrective
because
action regarding-
we did give them until 4/3 for the advertisement in the notice. So we're going to go $1,000 per comment, $250 until the property is compliant with the advertisement. I just know Madam Magistrate usually give a day or two.
Yeah, well, I'm looking at your notice to make sure when they were notified of that, because it says that you have until 4/3 to change the advertisement, and then it only mentions the irreversible nature of 5,000. There's no There's no notice of the 250 or for per day. In the notice. Okay,
I understand.
I'll take a look at that. Okay. Is there anyone here on behalf of Ms. Jones, or is Ms. Jones here? Good morning. If you could please, whatever it is at this point, if you could please come up, state your name and affiliation with Ms. Jones for the record.
Yes, of course. My name is Bryce Williams. I'm an attorney on behalf of Rebecca Jones, who's here today to my right. First and foremost, in regards to the advertisement, $250, it has been changed. It is no longer advertised as a one-night rental stay. I know you mentioned the actual notice of that violation in the notice that Ms. Jones received. So we would ask that to not be considered at all. As for the 4 reviews that were shown by the city, Ms. Jones is from Nebraska. She moved down here to build a property. She bought this property in St. Pete Beach and was living in it at the time. The construction of her house was taking place. She was living there, and then when her house was completed, she moved out and decided to rent out the property. She was unaware that these types of restrictions were put in place. She ran an Airbnb business in Nebraska. No such provisions or restrictions in any communities that she rented Airbnbs at in Nebraska had any sort of similar restrictions, so it didn't even cross her mind to look up these possible transient occupancy restrictions. She is fully in compliance with the code now. The only way to book her place is to have it for a 30-day minimum stay. She's also planning on selling the house now that her house is completed where she's living at now. So there isn't a continued risk moving forward of her violating this code again. We would ask that, based off precedent set at this hearing today, that she be issued only a $250 fine for each of the violations instead of the suggested $1,000. The reason being that she was completely unaware, and that's kind of the basis of our defense, is that if she would have known that what she was doing was wrong, it wouldn't have occurred in the first place. She likely wouldn't have even rented out the property at all and just moved right to sell it instead of renting it out after the construction of her current home was completed. And for the record, I'd like to notate that one of the reviews, the one that was specified Dominic, that was a photo shoot that occurred at the Airbnb. The purpose of that booking on Airbnb was for a photo shoot to be conducted for a business, Dominic's business. So I would just like that notated for the record, and we would ask for a $250 fine other than the $1,000 that was recommended by the city.
Any questions from the city?
I do. Thank you for the clarification on Dominic's, but how long were the other rentals? It says a few nights.
The other ones that were
Yeah.
posted on there, they were less than a month, correct?
How long? A week, 2 weeks, 5 days?
Yeah, the other ones.
Yeah, one was, I think, a week. One told me they were gonna stay a month. Actually, they told me they were gonna stay longer, and they ended up not. But I didn't know that there was such a thing. So, being in Nebraska, I own a medical staffing company, and we were placing traveling nurses and doctors during COVID. So I had a lot of different Airbnb properties that I placed a lot of the traveling nurses in because there was no housing available for them during COVID. And that was just something that I did in Nebraska. I had very high-end properties, and I thought that, okay, well, maybe I'll just do it with this property. And then I found out that I called an attorney because I never heard of this before. So, and then when he advised me what to do, obviously now I'm gonna most likely just sell the property since I can't use it as short-term rentals, which is unfortunate because my house is beautiful and it's great for families, and it's set up for families that have children, and a lot of people can't find properties for their pets. So I just thought I was doing something good for the community, so I apologize if I did anything wrong.
Thank you for that. Madam Magistrate, the reason I asked how long these were is because the property owner is charging $765 per night to stay there. So we are not in agreement with reducing the $1,000. I mean, that's practically one night at her property. So we think that's more than fair.
And there was discount rentals on there, and I think that there was discounts for the first few rentals. There was significant discounts for people. So some of those weren't being rented at that price.
Yeah, I would like to notate that pricing that can be set on the app, it can fluctuate, it can vary.
Understood.
I can't speak.
It does say average pricing, I understand.
Right.
Anything else, Ms. Jones or Mr. Williams?
No, ma'am.
Okay, anything else from the city? Okay. I'd like to clarify something for the record. There is no precedent. So because I ruled one way in one case based on the credible testimony of the respondent and the reasons being for why and their potential ignorance, et cetera, may not apply in another case.
Understood.
Based on the type and quality of testimony, I do stay consistent throughout my orders. As I've said, and you've heard, if you've sat here long enough, ignorance of the law is not an excuse to the law. And so just because in Nebraska there's no laws, in Florida, if you pick up a newspaper any given day of the week, one of the largest debates in our state is short-term rentals and vacation rentals. So with that being said, there were 4 nights. I understand Dominic's was for a photo shoot, but it sounds to me there wasn't any testimony that said it was of a 30-day nature. So to me, that's still a short-term rental, especially given the definition of transient occupancy. So I am going to find that the property was in violation for the 4 nights. I will assess the $1,000 per stay fine. And as you've heard, if you've been sitting here, there are ways under the code to come back and see if that can be reduced. I will get you an order staying the same. Please, Mr. Williams, you just make sure we have your contact information, and I will send it to you in writing.
Perfect. Okay, thank you.
Plus the $325 in administrative costs.
Read my mind. Thank you, ma'am.
I write it down and then I don't say it. Okay. Thank you.
Thank you, Madam Magistrate.
Moving on, agenda item number 6, cases complied. There are none. Number 7, old cases. Case number 2023-0511, City of St. Pete Beach versus Randall Rudder, trustee of the Rudder Living Trust. This is a final hearing to impose final costs, is what it says. Mr. Rivera.
Yes, Madam Magistrate, Stephen Rivera, on behalf of the City of St. Pete Beach. So we had Mr. Rudder back in, I don't know the date off the top of my head, was previously adjudicated and was given time frame to get the dock out of the dune system.
Right.
He has completed it a little bit longer than we expected, but it wasn't his fault. DEP had a hold up. So
sounds about right.
I just want to submit the evidence, the photos, the dock being removed from the dune.
Deck.
We did replenish the vegetation with approved plants. And this was taken back in the beginning of, or March 4th, beginning of March. I'm sure by now it's probably grown in a little bit better, but it's significant, sufficient ground cover that was placed in.
Okay.
I don't know if you have the prior order in front of you.
I do, so that was going to be my next question. My order is dated October 12th, and it gave, once the platform was removed, it gave the respondent 60 days from the date of the notice to put in the landscaping. That was because of FDEP having to be involved and all that entails. So when the removal was completed, did the property owner complete the installation of the landscaping within the 60 days or sufficient enough for the city to say he's complied with the order?
Yeah, he was in contact with us throughout the whole process. There was an issue with the landscaper being able to get the plants to he was worried about it getting close. They got it in, everything was good, but it was the back and forth holding off and waiting. He had a late start because DEP took so long to respond to our notice and getting in touch with him.
I do have one question. How much are the admin costs here?
It's I think we're.
It is $325.
Yeah.
I didn't know if. Okay. So there will be no further request from the city minus the 5,000 fine for the initial violation.
I was going to say, I've already assessed the $5,000 fine for irreversible or irreparable, and then the administrative costs, which are $325 pursuant to the city's testimony.
Correct.
So
The only point of clarity for the city is
certainly.
it said will be imposed, so we didn't actually do anything.
Correct.
So
And I will draft an order imposing
Okay.
that fine and the administrative costs, as that could have gone very differently if he didn't comply with the order as stated, and also pursuant to Chapter 162 in this fund bifurcated system that we have. So I will go ahead and get an order imposing those fines and costs. Before I do that, is Mr. Rudder here, and would he like to say anything? I didn't see him come
I
in,
spoke
so.
to him. He had sent me an email letting me know that he was in compliance. I told him I was going out to the property to take photos. He's back in Kentucky, I believe.
Okay.
It has no plans to be here until the summer.
All right, just for purpose of the record, nobody is here on behalf of Mr. Rudder? No one? Good, okay. Okay, I will get an order to that effect and send it to all parties involved.
Thank you.
And moving on to case number 202305559, City of St. Pete Beach versus Lake Merritt Partners LLC.
So, Madam Magistrate, on Thursday late, the city received this. I'm going to go ahead and, as a courtesy, submit it in to the record. It's a withdrawal of their request. As you can see from the agenda, there was a notice of appeal filed. And if you look at the overhead, this is what their attorney sent. So.
Okay. Well, I will accept, not that I need to, but I will accept the request to withdraw the hearing to challenge the fine amount. There will be no order associated with this.
Thank you.
Moving on to case number 202305513, City of St. Pete Beach versus April Elliott and David, I got this last time, Robarzik? Robarzik. Okay. All right. Oh, Mr. Dewar.
Madam Special Magistrate, good afternoon. Pete Dewar, Code Enforcement Manager on behalf of the City of St. Pete Beach. April Elliott is here to, are you appealing the fine?
Yes. Yes, it says it's a challenge to the fine amount.
Correct. Yes.
Okay, so since this is, Ms. Elliott, since this is your specific request, if you'll come up and just state why you were seeking to repeal or reduce the fine amount.
Certainly. So if you will recall, we were present at the February hearing, my husband and I, Mr. Robarzik, updating the court and alerting the court to the fact that we were attempting to sell the property. We disputed, obviously, the situation of the fence, and the court accepted that. We did obviously accept ownership of the dumpster enclosure and indicated that we were more than willing to work with the city in terms of resolving that. The court and I believe the city attorney at that time indicated, that they didn't want to disrupt the sale of property, and so we were given an extension to resolve that and advised to work with code enforcement in terms of how best to do that, whether we could paint it or needed to remove it or what may be. My husband did confer with Mr. Cruz about that. It was determined that we could simply demolish the fence. That was going to be the cheaper option. We did have a number of showings scheduled once we listed the property, so we elected to not move immediately on that, but we certainly intended to do it. We did receive this court's order to appear at the March 11th hearing, which was set for a status conference to update the court as to what was happening. We had every intention of doing so. However, that weekend, my father had a medical emergency. So I do have, my boarding pass that I even saved to show that we flew out late on the evening of March 10th to attend to my father. They live in a pretty rural part of Dallas. There were flight delays. The boarding pass even reflects that, and so I can show this to the court.
If you would like to submit it as evidence, that's fine, but I take your testimony as credible.
Long story not so short, we didn't arrive to my parents' house until almost 1 a.m. The night before. I did set my alarm because we're on Central Time there to alert Mr. Cruz to the fact that we would not be able to attend the status conference. I made every attempt possible to attend this hearing virtually, to either call in or Zoom or whatever this court would allow to give an update. I also emailed both Mr. Rivera and Mr. Cruz at 9:24 that morning. Obviously not sure whether or not they would get that in time, but again, this is 8:24 Dallas time. I breathed a great sigh of relief when Mr. Cruz alerted the court to the fact that I had emailed him that morning. I was very grateful that he had received it. However, respectfully, he was rather choosy in what he chose to relate to the court. So he stated that we had spoken to him, we had been advised that we could remove the dumpster enclosure. What he did not say is that I had asked if we could appear virtually. He did not say I had asked if we could call in. He did not say that if we could not, I was requesting one final extension. He did not say that I said that we had spoken with our general contractor that morning and confirmed the fact that he could and would remove the enclosure as soon as the permit had been accepted. None of that was relayed to the court, so it was very painstaking. And he did not say that I also emailed and said we are appearing virtually, we are watching live. All of this I said, and as our case is called, I sent a second email saying we are online, we are here, we can answer any questions that the court may have. None of this was relayed to the court. So it was very painful to hear the court say, is anyone here on behalf of respondents, and hear complete and utter silence. Nothing about, well, I do know that they're online. I do know that they're requesting an extension. I do know that they would like to call and speak with the court and provide an update if they can. I do know they spoke with the general contractor this morning, and they are working to resolve this. None of this was said. So we watched from Dallas this court impose fines and costs, which are obviously exorbitant. However, that said, immediately upon the court's ruling, I called the contractor again. He came and applied for the permit. That has to be notarized by us, so we're in rural Dallas. My parents live in like horse country, so my husband and I are driving around trying to find a notary who can notarize the permit. Regardless, the permit was notarized and applied for and filed with this office within hours of this court's ruling. So that was done same day. We waited, I want to say 3 weeks for the permit to be approved by the city. And I have text messages and emails with our general contractor to reflect those communications. Do we still not have approval? Do we still not have approval? We didn't, but once we finally did, within, I want to say 3 weeks, the permit was finally approved, despite it being filed the same day as this court's ruling. The enclosure was removed within hours of the permit being approved the same day. So the enclosure's been removed. It's all done. The final inspection was last Thursday, I think, and so I have that. We stopped and got that off of the building, so I do have the signed inspection and approval, so that's been done. So we truly have been doing everything that we can to be compliant with the city. It's just we've experienced some hurdles, but thankfully they are behind us. But I am asking the court to please rescind its order regarding fines and costs. It was not our intention to to delay things. This was completely on property. It wasn't obstructing any thoroughways or byways. It wasn't, the integrity of the structure was never at issue, so it wasn't, I don't think, a public safety hazard. This has been in existence for years, to my knowledge. So I don't feel like we were putting the community at any harm or public safety at jeopardy. So, again, we've done what we can, what we've could. I did attempt to appear at last month's hearing and attempt to update the court. What I also indicated in that email to Mr. Cruz and Mr. Rivera was, I know they said that I said, you know, when there was a lull in showings, that's true, but I also said that we anticipated it could be done within the week. That also was not relayed to the court. So I just want to make the court aware that we weren't trying to sidestep this court's orders.
Okay. Anything from the city?
Yeah, well, I definitely understand your situation, and I'm empathetic towards it. I just want to clarify that this is not a lien reduction request. This is a challenge to the fine, and Madam Magistrate, respectfully, in our code, you're limited to consideration of only such new findings necessary to impose an appropriate fine.
I understand that, and I agree that some of the testimony that's been presented would address that, and a large portion of it does not.
Well, and so I guess the point I'm trying to make is there was still a window from February 14th to March 11th to get a permit. They left on March 10th, which was the day before. I highly doubt they were going to get a permit the day before the meeting anyways. I don't really hear anything that should change your opinion on the fact that they had until March 11th and they didn't get it. Their attendance here, and why I can appreciate that. I mean, you had the special magistrate's email. You could have emailed the decision maker there. It's really not Lewis's responsibility to advocate for property owners. I understand that you were upset, but generally speaking, I don't really like in quasi-judicial procedures people to be on telephone. It's very hard to hear. It's very difficult to do. So yeah, Madam Magistrate, I don't think, from the city's point of view, I can understand the severity and family first and those things, but the reality is there was a 30-day window that they did not obtain a permit, whether it was because they were selling it or what, the permit wasn't obtained.
And if I may briefly respond.
Ms. Elliott.
To be clear, I did review this court's final order after the February hearing, and there was not any order to obtain a permit within that 30 days. The order was to confer with the code enforcement officer and to then appear for the status conference. There was not a specific order to have obtained a permit within that 30-day window. That was not the court's order. It was to confer with the code enforcement officer, which we did do.
Right. So my order, for purposes of the record, from February 15th, 2024, said respondent shall have until Monday, March 11th to meet with the city to determine if the dumpster enclosure can be removed or if it needs to be replaced, and to make a good faith effort to complete the removal or replacement before that date. And then it says a status hearing would be set for Monday, March 11th. At that time, it will be determined what the status of the property is, what actions are being taken to remedy the violation, and whether an extension of time is needed to complete those tasks, or if fines and administrative costs will be imposed as a result of the failure to make a good faith attempt to comply with the code. I agree that your challenge to the fine amount is well, not credible, but it is substantiated as there are new findings necessary to impose an appropriate fine and create a lien. That being, I did not know that you weren't able to appear and you tried to appear virtually. That being said, there were extenuating circumstances, there are things that you would have done, but all of that to say nothing changed what your testimony is here today, which is you were going to defer either the removal or the replacement of that dumpster until you had gotten showings done. So you could have met with the city, applied for the permit, had the permit, understanding it's a cost-benefit situation, done that at that time, and then done the showings. So the permit process doesn't require somebody to be on site. You could have still done your showings and gone through the permitting process to remove that dumpster after those showings were done. Again, just like Mr. McConnell said, I am empathetic. I don't know what your father's situation is, and I hope whatever ends up resolving favorably, but, and while this is an equitable proceeding, I don't find that the new evidence that's being presented here today would have changed my mind on what that associated fine would have been. Now, again, to Mr. McConnell's point, there's a fine reduction provision within the code, but I don't think, and I was lenient, I think, on my fines of $250 a day for something that is the removal of a dumpster. Once it was determined that it could be removed, it's a mere permitting process in removing the dumpster. So understanding that, like I said, there's a cost-benefit analysis. My ruling on the reduction of the fine request is going to be that I don't find that there is sufficient evidence that would have changed my opinion at the March 11th meeting to today on the $250 a day fine. And I am going to keep the order as stands, and no reduction in fine will be given at this time.
So we can't have a reduction for the time that we waited for the permit to be approved by the...
You have, no. So like I said, that you had from the date of the hearing, really, even though it was from the date of my order, you really had from the date of the hearing because you're on notice of that deadline, to say, okay, we know that we have to take down the dumpster. We're going to make every effort to apply for the permit. And then if you had come here today and said, we applied for the permit, we still haven't gotten it, we just needed an extension of time because we were delaying because of the showings, but we made every effort to apply for the permit to have it removed, but this emergency happened with my family and we had to go, we weren't able to attend the hearing, that would be a different set of circumstances because there would have been a good faith, reasonable effort been made to remove the dumpster from the property. The fact that the permit didn't get applied for until the end of the time period allotted for in my order, that's what isn't, to me, is the linchpin here on whether or not these fines are going to be extinguished or otherwise reduced. I think the fine amount, based on the new evidence presented today, is insufficient enough for me to reduce that $250 a day fine. Not to say there's not other provisions in the code to ask for lien reductions, et cetera, but for the parameters I'm given in the code, the new evidence would not have changed my mind at that March hearing if you had been here.
So the $250 a day began when and ended when?
Pursuant to my order, it began on March 11th, 2024, and runs until the property comes into compliance, which is a determination made by the city.
But I believe she's testified. That's kind of what I was alluding to.
permits
There's
are-
a lien reduction. What you did was challenge the actual lien,
The fine amount.
the fine amount, but there's a lien reduction application once your property is compliant that you can apply for to reduce the actual lien imposed.
And who do I contact for that?
Right behind you, they can give you the application.
And it is different standards of review. So for this particular standard of review, I don't find the evidence sufficient enough.
And may I inquire of the city whether or not our neighbor, who we proved does own the fence that we were initially cited for, have they been cited?
I'm going to say that that's something that you can inquire for offline, but that's not pertinent to this application or to this motion or
Well, it's
request.
pertinent to the sale of our property.
It may be, but your sale of your property is not at issue here today for the request that's being
understand that,
made.
but we were cited for it initially, so I'm just curious to know whether or not they have been cited.
And I think you could ask the city offline. Thank you, Ms. Elliott.
Thanks.
Okay, moving on to agenda item 8, lien reductions. Case number 2023-0291, City of St. Pete Beach versus Nemeshon, Inc. Do I have, yes, Mr. Dewar.
Good afternoon, Madam Special Magistrate Pete Dewar, Code Enforcement Manager for the City of St. Pete Beach. As you're aware, this is for lien reduction. We have the lien reduction application. Please go to the overhead. And this proves that the taxes were paid. The property is now compliant. and fines accumulated to $29,680, of which the lien was $29,250, plus administrative costs of $430. The city is asking for $5,850 and the administrative costs of $325 for a total of $6,175.
Okay.
Is someone here?
I was gonna say, I'm not so sure the city's requesting anything.
Yeah,
That's
no.
great.
Oh.
I didn't see a request in the application.
So, if you could please come up, state your name and your affiliation with Nemishan LLC.
Yeah, Kerry Blacksburg, attorney for Mr. Shaw. You want the power of attorney?
No, you're an attorney, as long as you're properly licensed by the Florida Bar.
I think I am.
Never know these days.
I've been dealing with this, quite honestly, for quite some time for him, and it's really kind of boiled down to an issue of a contractor that didn't know what they were doing. Wrong surveying, and a contractor actually stating that he didn't think he needed a survey to put in a new fence. And I appreciate it. I know my client actually spoke to
Mr. Dewar.
Pete, sorry. Prior to this, and they told me that amount, which is extremely fair, quite honestly. The only thing that I request, and I want to see if it would be possible to be granted, is all of this, the work that was requested to be done to this property was done as soon as he got notice. The notice was left at the property. I don't think he ever got correct notice. We ended up taking on and speaking to everyone. And after speaking to the client today, he requested that I ask the city to take $4,500. And that's,
Okay, so the request is to reduce the $29,250 plus the $430 in administrative fines to $4,500.
yeah, I mean, I know all the facts were already gone through in this case. I don't really want to go rehash all that.
Right.
And I don't think there's any reason to.
Okay, and the city is offering a counter reduction to $6,175.
Inclusive of admin costs.
Inclusive of a reduction from $430 to $325 for admin costs and a reduction from $29,250 to $58.50 for fines, or for the lien. And your assertion today is that that seems like a fair amount.
It is, and just to be honest, I mean, and in all honesty, just looking back at the file itself and all the emails going back and forth from the city, this should never have told to where it is in the first place. It was immediately received, and I mean, I can give you the contracts and the email, and again, I don't want to waste anyone's time. So
Yeah.
that's why, you know,
And I don't really have it, I mean, my criteria is, did they meet all of these things, and
it was a pretty long list.
is the reduction appropriate? So,
And I think, well, the tolling period for the original fines includes periods that were
right.
there with the property that was actually in compliance based on there was some new notices as far as the fence that they put in was 5 inches off. And then there was multiple emails straying back and forth for, quite honestly, beginning prior to the original notice of the contractor who, if you want the name, I can give it to you, between the contractor and the city, Elena Grundy. Back and forth, requesting, you know, hey, the permit says it was done, and then it went back to inactive or invalid, and back and forth with the survey company who did something wrong, and it kind of spiraled out of control.
Okay.
And with this client who's a doctor running a different business, not at this building, he really didn't, and trusted this other person to do this.
Okay.
So.
Any response from the city?
No, respectfully, I think 20% is more than fair. And if we need to make arguments, I mean,
I mean,
if he has like compliance dates that are before January potentially, but
there's compliance dates in November.
With the order asserted, or.
I mean, it came back out with another order. And like I said, I don't want to sound petty, and I really don't, because I do think, based on numbers, it looks fair.
Numbers alone.
I'm just saying that there was, it seems to be there was a lot of
Back and forth.
but also some miscommunication between multiple parties.
Okay.
As far as the tolling of it.
Okay, so I understand the request is for 4,500, and I understand the reasonings behind that. The reduction to 20%, I think, is fair, and you've said it seems pretty fair and equitable, so I'm inclined to go with a reduction from $29,250 for the lien to $5,850, and then the reduction in the administrative fines from $430 to $325 for a total of $6,175, which is not far off from the $4,500. Based on the proportion from the original fine and lien, and I will get you an order to that effect. Just make sure I've got your email address, I'll send it straight to you.
Thank you.
Great, thank you so much. All right, case number 2023-0340, City of St. Pete Beach versus Paradise Caprice LLC. Another lien reduction request.
Good afternoon, Madam Special Magistrate Pete Dewar, on behalf of the City of St. Pete Beach Code Enforcement. Another lien reduction. And as you see there, the amount they're requesting the fine be reduced to is $5,000. Would you like to read these, Madam Special Magistrate?
I have read them previously, but yes, I will go through it one more time just to refresh my recollection. Yeah, okay, I recall this, okay.
The taxes have been paid. And so the city is going to request, the fines total $61,430, of which the lien is $61,000, the administrative cost is $430. So the city is going to request $6,100 plus $430 for a total of $6,530.
Okay. So the city is willing to
To a 90% reduction.
counter.
90% reduction.
A 90% reduction to 10% based on, and the request is $5,000.
Yes, ma'am.
And just to clarify for the record, based on the gravity, the effects of the surrounding properties, just so there is criteria behind this, the city manager was willing to accept 10%.
Okay. And Ms. Savino, you're here on behalf of the property owner?
Simone Savino, Stearns Weaver Miller, here on behalf of Paradise Caprice. Yes, and I just wanted to say thank you to staff for being so helpful through the process. We do appreciate you the city taking the property owner's mitigation into consideration with this request.
Okay, and Ms. Savino, I know that your client's request was for $5,000. Based on the reduction that the city is willing to take of the $6,530, do you have anything other than what you've detailed? And what I appreciate is a detailed response for the application that would warrant the additional $1,530 reduction.
I want to make one note, and I'm fully on board with what's already been discussed. We had done a public records request prior to today's hearing just to gather all the documents, notices. So the client themselves were saying that they had an issue receiving the original notice of violation. I didn't see anything documenting the certified notice in those records. The way they came about this original notice, which was kind of the cause for their delay to start the process, was the posting. So I just wanted to note that. That's the only thing I wanted to add. I don't believe I included that information here. So we just couldn't find, and the client themselves were saying they just didn't get it in the mail. So I think there was an initial delay, and then there was not a lot of understanding of how the process was to be worked out in person, coming down here, talking consistently to the code enforcement team, and so therefore there just was additional delays after relying on an unreliable contractor.
Okay. And understanding and noting your notice issue, that is obviously something that should have been brought previously when the case was being first prosecuted. Based on that, I appreciate that the parties are $1,500 apart, much like the last case, though there's not precedent. I will accept the city's reduction to the $6,530. Again, I do appreciate that. That's more than we usually get for a lien reduction request. So, but I will get an order to that effect and just make sure I have your contact information so I can send it your way.
Thank you so much. Can I leave my card with the clerk?
You can, and I believe I already have your email address.
Okay.
We're okay.
See you. Take care.
Yes, you too. Okay. So our next meeting is going to be.
I have one more.
No, there's no.
Special Magistrate.
It's not on the agenda.
Yeah, it is.
Wait, what?
No.
Well,
Oh, I marked it off without announcing
Yeah.
it. Gosh, what a happy accident for me.
Yeah.
I know. Oh, goodness. Okay. Case number 2023-0541, City of St. Peach versus Wilmington Savings Fund Society, FSB, trustee Pretium Mortgage Acquisition Trust. I'm pretty sure I say that differently every time I say it.
Madam Special Magistrate,
Yes.
Pete Dewar on behalf of the City of St. Pete Beach, and we promise this is going to be the last one.
Don't make any promises you can't keep, Pete.
Oh, no. This is the lien reduction application. And the amount being requested is, the amount that they're requesting the lien to reduce to is $1,700. This is a letter. Have you seen this, Madam Special Magistrate?
I have. My only question with this letter is that this letter says that they're asking for a lien reduction, but have retained the firm and either Theodore, I'm going to mess this up, thank you, or Tyler Mesmer, and I'm well aware that you are neither of those.
No, but I do work for Tecuzas and Associates.
Okay.
And I believe she did show up to
She
one.
was at the last hearing. I just wanted to make sure because,
Yeah.
you know, it was very specific in their letter, but yes, okay. Yes, I have read the request.
Thank you, Madam Special Magistrate. And the taxes have been paid. And so the city is countering the $1,700 with.
It's consistency, it would be 10% of the 16,905, which would be 1,690 plus the admin cost of 405, so.
You guys are pretty close.
It'd be 2,090, 2,095. Right, because it'd be
Wait, it's the so you're taking
10% of
10% of
16,950.
1650.
So, no, 16.
You're taking 10%.
Oh, yes, no, you're right. You're right. So it'd be 19.
$2,055, right?
Yeah.
That's
You're right.
$1,650 from the lien.
What?
Yeah, it's $1,650, so it'd be
Too bad.
$1,650.
Right, plus the 405 in admin fines, which gives you $2,055, unless you're asking for a different, or unless the city is willing to accept a different amount, because I believe the applicant has asked for $1,700 flat. Thank you. So the city's position, Pete, the city's position is, what are you willing to accept? Just so I make sure that my math is.
Matthew? Mr.
Yeah, I
McConnell?
might have misspoke, but I've already said it. 10% of 16,500 plus admin, so it'd be 2,055.
Okay. And you guys are $300 off. So I am going to accept the city's reduction of the 2,055 with the 1,650, which is actually the lien amount is reduced less than the ask, plus the $405 in administrative fines for a total of $2,055. And I will get you an order to that effect. I believe I have your email address, but if not, please make sure it's on the sign-in sheet. And now we are done. Yes, now we are done with all of the cases. I will double check that one. So our next meeting is May 13th, same time, same place. Anything else that we need to take care of? We're all on the record.
No.
Okay.
Thank you.
We're adjourned.
Thank you.